Aizawl Bench for delivery of judgment item number 1, WPC 57 of 2023.
Petition dismiss being not maintainable.
May it please your lordship. I'm praying for listing of this matter for admission, my lord. The matter was last listed in July, my lord.
When do you want?
My lord, for listing, my lord. For listing, my lord.
When?
My lord, any day convenient to your lordship, my lord.
On 25th November.
My lord, I'm deeply obliged, lordship.
May it please your lordship. Lordship, I beg to mention for listing a matter for admission, lordship. In this matter, what has happened, lordship, in spite of this honorable court order, lordship, my provisional pension has not been paid, lordship. Provisional pension, lordship.
When do you want?
Lordship on Thursday, lordship,
Thursday.
6th of November, lordship.
So many cases this week, lordship, next week any date. On 14th.
Can it be on 13, lordship? Oblige your lordship.
May I please, my lord, I beg to mention for listing on admission matter, my lord. It is similar relating to my lord medical reimbursement, my lord.
Revision method?
No, my lord, my lord, medical reimbursement,
For
my lord.
medical
Yes, my lord. So, my lord, kindly,
When?
my lord, in this week, my lord, any date, my lord.
On 12th November.
Obliged.
May it please your lordship, in item number 39, my lord, we're filing an additional affidavit, my lord, that may be called for, my lord.
May I please your lordship? My lord, I am praying for listing, my lord, a pension matter, my lord.
When?
This week, my lord.
So it may not be possible. Okay.
14th November.
Obliged.
May it please your lordship. Lordship, I beg to mention for listing of a fresh matter for motion, lordship, which was filed on 28th October, lordship. But
When do you want?
on Friday, because Wednesday is a holiday, lordship, on Friday, lordship. on Saturday. Oblige.
May I please, your lordship, I beg to mention item number 26, lordship. This matter may be fixed on next week, lordship.
Why?
Lordship, today it will be difficult, lordship. We have taken, it will be difficult today, lordship. We have taken consent from the other side, lordship.
Ms. Counsel, learned counsel, appearing on behalf of Mr. Ezekiel, learned standing of NCP. With consent, preside, press for listening the matter on.
Monday, lordship.
On 10th. 10th.
Highly obliged.
Yes.
May it please, my lord. Prayer for listing of a IA, my lord, in a writ petition, my lord, for tomorrow, my lord. There is some urgency regarding some alterations in the order, my lord, which was passed previously by this honorable court. It is my lord's order. In fact, for tomorrow, there is some urgency, my lord. I'll satisfy. I am deeply obliged.
Lordship, I pray for listing of a writ petition for motion, your lordship. Can it tomorrow, lordship? There's an urgency, lordship.
Tomorrow hearing. is-
Hearing there.
Can it be on Friday, lordship?
May I please? Sir, I'm praying for listing on motion contempt matter. It may come on Friday.
Friday, we have given this. On Monday. 10th.
And Wednesday,
Okay, 12th.
Wednesday,
Friday or Monday, 10th.
Monday.
May I please, your lordship? I beg to mention item number 33. I am for a petition, lordship. I have taken consent from the other side.
33.
Yes, lordship. Contempt case, my lord. There is some development, lordship. Matter will come after 2 weeks.
Learned counsel. For the petitioner with consent from the other side, plus listening the matter, but
After 2 issues.
after 2 weeks. Fair enough.
Deeply obliged.
May it please your lordship. Lordship, item 25. This is, my lord, a motion matter, my lord. This is fixed today for considering interim order, suspension matter, my lord. So urgency, my lord, but wrongly listed in admission column. May I pray to take up a last item of motion? Motion matter, my lord, wrongly listed.
Okay, anyway, we will take up the matter today.
It's last item of motion, my lord.
I am assuring you that I will take up. the matter today.
Deeply.
May it please your lordship. Lord, I beg to mention item number 9 to 12. And I've informed the.
9 to 12.
9 to 12. Can this? 8 to 12. 8 to 12, sorry.
8
No,
to
no,
12, your
8
lordship.
to 12.
In 8 to 12, lordship, we have filed an affidavit today, your lordship.
In item number
8 to
8 to
12,
12.
8 to 12.
lordship.
So let this matter come up on 20th of November, 20.
On 13th, your lordship.
13.
On 13th, your lordship.
13th,
It's a part heard matter, your lordship. It can be taken up for disposal on 13th.
or 21st, or 21st November.
21st, lordship.
Okay, Mr. P. Kosik. Learned Standing Council for the Secondary Education. Secondary or elementary? Elementary.
Elementary.
Elementary Education Department with concern with others at risk of distinct of with cost of fair load.
May I please, your lordship, my lord, I beg to mention for listing of two writ petitions, any date in the next week, my lord.
Next week, 14th. 14th. So item for motion bail application, item number 3.
May it please, your lordship. This is the second time application, my lord. These petitioners are behind the bar for about 1 year, my lord. Out of 21, my lord, only 6 prosecution witnesses have been examined, my lord.
6.
6 already been examined out of 21, my lord. They are behind the bar since 1 year, my lord. And I kindly call for the scan copy, my lord. I will try to satisfy your lordship, my lord.
Okay. Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. Dusk, learned additional people for the state respondent. This petition under section 423. No, 483 of the BNSS 2023 is preferred by the accused. Namely, Zahirul Haq, alias Zahirul Hussein, and Ramizan Bibi, who are languishing in Delazut in connection with session case number 366 of 2024. Arising out of Agamone PS case number 98 of 2023 since 12/11/2024. Under section 120B 302/34 the learned counsel for the petitioner submits that this is the second bail application preferred by the accused person. And that out of 21 witnesses cited in the search sheet, till date only 6 witnesses have been examined. And as such, the learned counsel contended that the state copy of the record from the learned trial court may be called for. Mr. Das, any submission? No. Accordingly, taking note of the submission of learned counsel for the accused and also the learned additional duty, it is provided that the SSL call for a scan copy of the record from the learned trial court. Fixing the matter on
19th,
sorted
14, 14.
Deeply obliged.
For motion item 4.
But matter may be taken up after some time. My senior Mr. Ken Chaudhary will appear in this. But
Item 5.
In this case, my lord, I had inquired. Yes, lordship. Earlier, I had submitted one instruction, lordship, that he has submitted a BA and BS certificate from Saudi Sharon Singh University, Meerut, Uttar Pradesh. So it was found to be doubtful. So we have written to that university for its genuineness of the certificate. That report has not come. Lordship, I have been informed that they are sending one instruction. Lordship, can you take it after some time? What instruction comes? I will apply.
Number 6.
Your lordship, kindly pass over for the time being. I will submit in another.
okay.
Item 7.
May I please, your lordship?
Mm.
Your lordship, be pleased to see the last order, lordship.
Yes, madam, what instruction is available?
Yes, Lord.
No, my lord, director has already written letter, but they need some time to furnish instruction, my lord.
Pardon?
My lord, they need some time to furnish instruction, my lord. Instruction is
Fine
there.
instruction. 1 week,
Lordship,
1 week.
My lord.
Lordship, we are facing difficulty, Lordship. In our school, Lordship, there are more than 500 students, Lordship. We have to provide midday meal every day by the school authority. Now, I am not allowed to have the, Lordship, provide the midday meal. So students are, Lordship, facing difficulties. So Lord, that is why, Lordship, last occasion I prayed for staying of this order, because the admitted fact is that petitioner is senior most. So although the petitioner is senior, Lordship, the respondent number 5 is allowed to hold the charge.
No, no.
So Lordship
part
may,
is,
the Lordship may grant they have some time to obtain instruction, but till then, Lordship, this order may be stayed. Otherwise, Lordship, this
No.
school is facing difficulty.
Already there is
Status
an
quo,
order of.
right.
Yes,
Just give.
but because although there is a status quo order, Lordship, since this order is not stayed, Lordship, where I'm not allowed to, Lordship, provide the midday meal. That is the difficulty. So considering the interest of the students, I have stated in my pleadings, Lordship, there are more than 500 students. So that is the last occasion I pray for, Lordship, staying of this order. But that is, and they also directed to obtain instruction, Lordship. But they again, Lordship, to pray for time. The admitted fact is that petitioner is senior. Lordship may stay this order, 14th of 10 order. In the meantime, they will get the instruction, Lordship.
No, who is holding the charge of the headmaster?
I am holding the charge, Lordship.
Then why you are not allowed to provide?
The,
midday meal to the
because there
student?
is no administrative order, because what happened, Lordship, here, when the earlier headmaster retired, transferred, Lordship, the post of headmaster is felt vacant. So immediately, Lordship, thereafter, Lordship, the school authority allowed me to continue the insertion of the headmaster. Then I filed the, Lordship, application to pass an order, Lordship, administrative order, and the Lordship may kindly have the letter. It is clear from the letter from the block LMT division officer that is issued on Annexure 10, page 33. Here it is clear, Lordship. Annexure 10, page 33. Lordship, the post of headmaster is fell vacant after he transferred. So thereafter, what happened in this letter, it is clarified. May I read this letter, Lordship? With reference to the subject cited above, I have the honor to inform you that Firdas Hussain, in charge headmaster of Lahori Ghat LP School, had been transferred to other district, and he had handed over the charge of in charge headmaster to so-and-so. This is the petitioner. The senior most assistant teacher, SSA contractual. She has been rendering her service as IC headmaster, head teacher of the said school till date without any departmental order. As per resolution number 8 of SMC, the school managing committee's executive meeting held on 21/8/2025 to hand over the charge of head teacher to the Hasna Begum as the senior most teacher of the said school. On the other hand, Sekhor Juti Rahman, he is the respondent of 5, regular of the said school, also submitted his prayer petition for providing him the order of the in-charge head teacher of the said school. So, as per resolution of number 8 of SMC's executive meeting dated 21/8/2025, Hasna Begum may be provided the order of in-charge head teacher of the said school for smooth conducting the school affairs. Now, after receiving this proposal from the block elementary education officer, the DI has Lordship passed this impugn order on 14th of 10/2025. Saying that the respondent number 5 is the senior most teacher, but from the date of appointment order, Annexure 1 and Annexure 4, it is already reflected in the last order of 24th of 10/2025. I am the senior most teacher, Lordship. I was appointed in 2012, and so far the respondent number 5, he was appointed in 2013. So despite the relevant Lordship, this
Okay. Madam, can you obtain verbal instruction from the block elementary education officer as to whether midday meal is provided to the
My-
student?
it is not, that Lordship may Lordship reflect in the order, Lordship.
No,
Adi log.
today,
Monday.
after some time.
Lordship,
Letter of tenants.
Lordship, Lord.
Number 38.
May it please, my lord. This is a contempt case, my lord. For violation of the directions of the court in my lord WPC 1824 of 24, order dated 9/5/25, my lord. If my lord kindly has page, my lord, 14 for a moment, is our representation, my lord. We have attached the certified copy of the order as well. At 15 it starts, my lord.
And let notice go ahead, this is.
My lord, may I kindly submit one small thing, my lord? My lord, there is one small urgency in this matter. Otherwise, I wouldn't have troubled this honorable court.
Urgency, we have to issue notice.
Yes, my lord. Can it be fixed on a returnable date then?
Heard Mr. Pierre Sharma, learned counsel for the petitioner. His petition under section 11 and section 12 of the Contempt of Court Act 1971. Dated Article 215 of the Constitution of India is preferred for willful and deliberate violation and for non-compliance of the order dated 9/5/2025 passed by this court in WPC number 182 of 2024. Where is the petition and the documents placed in the record? The order dated 9/5/2025 passed by this court in WPC number 184 of 2024. Let notice to the respondents returnable. For it,
My lord, may I kindly submit one thing, my lord? After that, my lord, may I kindly. My lord, what has happened is that this matter, my lord, this is regarding cancellation of our affiliation by SEBA, my lord. Now the Secondary Education Board, which is changed. Now, my lord, what has happened is that after the passing of this honorable court's order, my lord, a show cause notice was also given to us. We have duly replied, but there has been no outcome ever since. Now, my lord, unfortunately, the form fill-up has come up for the next matriculation session, entrance. So, my lord, that from 1st to 5th is the only last date, my lord. So, if we could be allowed to take dusty service or any other
Yeah.
alternative.
then returnable in 1 week or 2 weeks.
My lord, 1 week, my lord.
1 week. Returnable in 1 week.
Because, my lord, it's Guwahati
And
only.
by registered force with AD and also by usual process with it. 2 working days from today. Additionally, dusty service is also permitted. After effecting service by dusty public, the petitioner shall file an affidavit of this court. Place the matter on forwarding it after 1 week.
Date of the kindly devote, date of the 12th, 6. I'm deeply obliged, my lords.
Yeah, the affidavit has not been received.
My lord, we
After
have,
some time then.
my lord, we have filed today, my lord, just now. So, my lord, may I pray, affidavit is vital, my lord, some important documents we have brought in on record, my lord. Can it be taken up on Thursday, my lord, coming Thursday?
Thursday. Okay. Any objection?
What is, my lord?
Huh?
My lord, 7th, Friday, my lord.
Friday?
Right.
Okay. Heard Mr. A.R. Munya, learned counsel for the government. Mr. Ardhar, learned discontent counsel for, you are for respondent number?
Your
Respondent number of, but for tribal affairs, my lord.
Tribal affairs.
Tribal affairs, my lord.
Tribal affairs.
5, 6, 7, 8, 9, 10, 11, so many respondents, my lord.
Tribal affairs. And you for?
BTC.
BTC. Case for
BTC.
Thank you.
Is care for respondent number 1 to 4. Mr. A.R. Munya, learned counsel for the petitioner submits that he has filed an additional affidavit bringing on record some important documents, but the same has not been left on record. And he tries for listing the matter on Friday.
Mal.
They are allowed.
7th,
Shall list the matter on Friday along with the additional affidavit filed by the applicant.
Oblige, my lord. File it.
item 40,
My lord, in this case, last three occasions, my lord, government has taken time to obtain the instruction and to complete the process, my lord. Last occasion also, my lord, learned friends, my lord, he was appearing. And to complete the process, my lord, take this actually some time.
Yeah, a specific instruction, Lordship, I have not received. Lordship, may kindly take it up on tomorrow, Lordship, or Thursday, Lordship. Thursday, Lordship.
Departments of also learned counsel for the petition, the SMPCC, learned content counsel for the respondents in secondary education department. Mr. Sisley submits that the matter may be listed on tomorrow or on Thursday, so as.
Thursday, my lord.
to receive instruction where allowed, this is a list the matter on
Thursday,
Thursday.
6th November.
Master bless, my lord.
Item 41,
Here, Your Lordship, we have to challenge selection of certain candidates for the post of Your Lordship, graduate teacher maths, Your Lordship, on the ground that Your Lordship, they did not possess the requisite qualification, Your Lordship. And in fact, they took time to bring instruction, Your Lordship, and also submitted that this is not the final list, Your Lordship. On the other hand, Your Lordship, at the same time, Your Lordship, if Your Lordship go through this notice, Your Lordship will find after filing of the writ petition, this notice was issued, Your Lordship. Asking the selected candidates to Your Lordship opt for Your Lordship the district, Your Lordship, in which they want them to be posted, Your Lordship. On the one hand, they are saying that this is not the final list, Your Lordship, they have not prepared. On the other, Your Lordship, they have asked the Your Lordship candidates. Your Lordship, may I read this, Your Lordship? In continuation of office earlier notice number so-and-so dated so-and-so, it is hereby all qualified candidates of the TETCOM recruitment examination, both of the posts of postgraduate teacher and graduate teacher, that an online portal will be available from so-and-so in the official website of the Directorate of Secondary Education Assam, which will facilitate the candidates to opt for all available districts for posting in order of their preference, Your Lord. Now, Your Lordship will kindly see my case, Your Lordship, essentially is this, Your Lordship. There is an advertisement, Your Lordship. That's at page 29.
Whether the respondents have filed their affidavit.
No, affidavit has not been filed. They sought time to bring instruction, Your Lordship. On last occasions. Your Lordship may kindly see the first order, Your Lordship.
We'll file the affidavit. We'll file the affidavit.
They will file,
The board report without their affidavit, can we hear the matter?
Lordship cannot hear, Your Lordship, but Your Lordship, if the selected candidates were, Your Lordship, allowed to be appointed, Your Lordship, then Your Lordship, ultimately, Your Lordship, I will not get the benefit of interim order. That's my apprehension, Your Lordship.
Lordship may fix it on 11th. We'll file the affidavit before that.
11.
11th.
And by that time, if Your Lordship appointments were
By
made,
that
Your
time,
Lordship,
nothing is happening. Why?
that observation can be, Your Lordship, recorded and
Not necessary. my lord. The
that is
procedure shall be
necessary.
such.
That
No,
is
no,
necessary.
that shall be such that before, that's why I'm saying, Lordship may fix it on 11th. Before that, we'll file the affidavit.
Okay. Heard Mr. Bortakur, learned counsel for the petitioner, Sir T. Mazumdar, learned. You are appearing in the capacity as additional advocate general for the state responsible. Mr. Mazumdar submits that the matter may be listed on 11th of November, so and in the meantime, the state respondents shall file their affidavit in opposition. That is accordingly allowed.
Right.
Any observation? Nothing.
Not necessary. my lord. 11th is just.
If Your Lordship, there will be no appointment, Your Lordship, that can be recorded, Your Lordship.
Once
It is
some
fallen
observation
from,
pass, then it becomes different. my lord. We are saying that nothing is happening. Lordship need not record that.
Okay.
If
Let us believe our additional advocate.
Yes, yes.
Lords.
item 42,
deeply aware.
May I please, your lord?
What's the page number 45?
Yes,
Yes, sir. Your lordship, in this case, I have been appointed as a principal in charge of the Mahur Public School. And thereafter, at page number 46, your lordship, one letter has been given to me regarding for promotional post, your lordship, on 26 May 2023, at page number 46. Thereafter, your lordship, without taking the conclusion end of this letter, thereafter, at page number 47, department has issued a notification dated 4th of October 2024 for the appointment of the principal. And your lordship, that has been challenged by me at page number 49 by filing a writ petition 3923.
Hmm.
So your lordship, thereafter, the department has assured me that they will give the effect to that 2023 letter. But, and on that assurance, I have withdrawn, your lordship, the writ petition. That is at page number. Your lordship, page number 50 is the relevant portion.
page number 50,
Yes, sir.
50. Page number,
50, 50, your lordship.
yes,
Your lordship, I have withdrawn the petition on the ground that the department will give the logical end to 2023 notification. And accordingly, but during the pendency of the writ petition, department has never disclosed the fact before your lordship that writ petition number 3068/2025 pertaining to the same subject matter is being pending. And after withdrawal, your lordship, that is your lordship, page number 81, your lordship.
yes,
Your lordship, the department has on 10/9/2025 has submitted before your lordship at para number 3 that Mr. Kaushik, learned standing counsel of the NC Hills, has produced one written inspection issued by the inspector of school Dimahaso before this court today and submit that the process could not be taken to its logical conclusion on account of the pendency of one writ petition, that is 3923. 2025, filed by one Srimati Nilima Majumdar, the writ petitioner in this petition, your lordship.
Hmm.
And on 20th/8/2025, the said writ petition has been withdrawn and now the respondent authority will conclude the selection process. So your lordship, the department has played in such a cryptic manner that on the one hand, they have assured me that they will give effect to the notification of 2023. And on the other hand, before your lordship, they have submitted that no, they will give the logical end to the 2024 notification, your lordship.
Hmm.
So accordingly, I have been affected and present before your lordship today.
yes, who is appearing for the?
Lordship, I am appearing on behalf of Mr. R.R. Kaushik. Lordship, in this matter, we need some time to get our instructor.
So when you will be able to obtain inspector?
Lordship, let it come after 4 weeks. In the meantime,
Why 4 weeks? In the meantime, you will complete the process.
no, Lordship, we will file our affidavit also. We have to file our affidavit.
Then let there be stay.
Okay, Lordship.
Or Mr. Sarma, learned counsel for the petitioner. And Mr. Your good name, please?
Shi Sharma, Lord.
C. Sarma, learned. You are standing counsel
Lordship, I am appearing on behalf of Mr. R. R. Kaushik. He is the applicant.
Learned counsel appearing on behalf of Mr. R. R. Kaushik. Learned additional standing counsel, Dima Hasso, Education Department.
I am appearing on behalf of respondent number 5, Your Lordship. Inspector of Schools.
Learned counsel appearing on behalf of Mr. R. R. Kaushik submits that the matter may be listed after 4 weeks, so as to enable them to obtain instruction. But Mr. Sharma, learned counsel for the petitioner, submits that after withdrawal of the writ petition number P925 of 2025. On 28/8/2025, the respondent authorities have issued a press advertisement dated 27/11/2024 for the same post. And thereby excluded the petitioner without any communication from an order of rejection or recall. And thereby the petitioner has been misled by the respondent authority, and under such circumstances, Mr. Sharma submits that the advertisement dated 27/11/2024. And what is it? It is pending. Advertisement
Dated 26 May 2023, page number 46, Your Lord. And they have issued page number.
advertisement dated 27/11/2024. You come to your page number.
Yes, Your Lord. So 27/11/2024 has been challenged by me, Your Lord.
Now, which one is to be state?
Yes, 27/11/2024.
As such, there is a requirement to state the advertisement dated 27/11/2024. Accordingly, taking note of the submission of learned counsel for both the parties and also comparing the facts and circumstances of the record, it is provided that pending further consideration, the advertisement dated 27/11/2024 shall be state till production of the inspection is received by the learned counsel for the respondent authority. This is a matter on.
On 21st November.
Hello.
Item 43.
Please, Your Lordship, can you pass over the matter for the time being, Lordship? My senior is on legs. So take him home.
Items for admission, item number 13, Pathan matter.
And please, your lordship. And please, your lordship. So, my lord, matter is handled by Mr. A. Fukan, my lord. He is in Andhra.
Oh,
He's on lakes, my lord. So, matter may be possible for the day, my lord. Matter may be taken any other day, my lord. On Wednesday or
pending since long.
Part matter is a long time.
Heard Mr. Arcidas, learned counsel for the petition. This N. Fukan, learned counsel appearing on behalf of Mr.
A. Fukan.
A. Fukan,
Yes, sir.
learned standing counsel for the respondent authorities. Price for listing no, price for adjournment of the matter for the day. Where allowed to list the matter on
Lordship, day after
Next.
tomorrow, if possible, Lordship.
day after tomorrow is holiday.
Oh, sorry, sir. I'm sorry.
On 12 November.
On 12.
Yes, Lordship.
Deeply.
Item
Pass
number 14, Pathan matter.
May please, Your Lordship, in this case, my lord, Your Lordship has heard the matter, and on 14/5/2025, Your Lordship passed an order to the District Elementary Education Officer to verify the ambiguity about the name of the petitioner and submit report, my lord. And my learned friend from the Education Department, Mr. B. Kaushik, appeared in the earlier occasions, my lord. Whether report is come out or not, my lord. Otherwise, Your Lordship has heard the matter, my lord.
14-5 order, my lord.
No, ऐसे से कोई direction.
Yes,
No, I am saying, madam, our instruction is awaited, madam, may take it up next Monday, madam.
Madam?
Matter may be take up next Monday, madam.
next Monday. You have not received instruction.
Madam, I have not received.
Heard Mr. M.A.I. Hussain, learned from
Next month.
that Miss Sutia, learned standing from people respondent, elementary education department, and you for BTC. It's open summits.
Education. Lordship, I have received instruction. I may be allowed to find a system.
Ms. Sutia submits that there was a direction to the district elementary education officer Torong to verify as to whether Azhar Ali, whose name appeared in the dice data of the petitioner's school since the year 2009, 2010, 2013, 14, and Azhar Ali, whose name appeared in the dice data since 2014, 15 up to 2022, 23, is the same person or not, has not yet been listed, and as such, she submits that the matter may be listed on next Monday, so as to enable her to obtain instruction. Here is the vote. This is a list of.
Lordship, I am sorry for this.
No, BTS is.
It is not
party.
here in the. It's not party. Not party here.
15, okay.
Hello.
10 November. Item number 15, Pathan matter.
Please, your Lordship. Lordship, I am entering appearance on behalf of respondent number 8, UGC. I pray for at least 3 weeks' time to file the affidavit in opposition.
Yes,
Lordship, 3 is
Lordship, I have
Long time
recently received the notice. I'm just entering appearance today. The affidavit will have to come from Delhi.
heard Mr.
RC Alam.
Learned counsel for the petition, and also heard
Dr. P. Agarwal,
P. Agarwal, learned standing counsel for UGC,
UGC.
and Mr.
DC Musahari.
DC Musare for respondent number 3. You? Respondent number 7. Ms. Agarwal submits that she may be granted 3 weeks' time to fight her counter affidavit. There is a lot of list the matter after 3 weeks.
Item 16, Pathan matter.
May I be- My lord, the petitioner was the, my lord, teacher serving in the Defendam school, my lord, and he retired from service. After his retirement, my lord, he was terminated. On the ground that he was,
Retirement?
after his retirement, my lord, and not after, my lord, 2 months before his retirement, he was terminated, dismissed from service. As because he was absent since 2011, he was absent due to his personal affairs. He could not attend the school, and on that ground, he was terminated. And this issue was raised before this honorable court in earlier round of litigation, my lord, at page 15, Annex 1. And this honorable court, my lord, while disposing that writ petition, has modified the punishment from dismissal to compulsory retirement. Paragraph 20 is the relevant, my lord, page 23. Reported in such and such honorable justice and such in his concurring Has your lordship got it? Page 23. Paragraph 20. BC Chaturvedi versus Union of India, reported in 1956, SCC 749. Honorable Justice Sarjan says in concurring part has elaborately discussed the penalty powers of this court under Article 226 of the Constitution of India. The provisions of Section 11A of the Industrial Disputes Act has also been taken into consideration, which empowers the Labour Court Industrial Tribunal to substitute penalties in case of a penalty of dismissal from the church. Following the aforesaid decision, this this court is of the opinion that there can be no impediment in exercise of power under Article 226 of the Constitution of India, and the only restriction is a self-imposed one under the facts and circumstances of the instant case. This court is of the view that the order of dismissal vis-a-vis the nature of the allegations may not be held to be proportionate. More so, when such dismissal disentitles the petitioner from the provision of all post-retirement benefits. This court has also noticed that the initial order of dismissal was passed on 12/1/2022, and immediately thereafter on 30/4/2022, the petitioner has suppressed the age of superannuation. The appellate authority in its order dated 27/2/2022 had also stayed the order of dismissal, which is ultimately upheld by the disciplinary authority in the impugn order dated 36/2022. When the matter was reconsidered on remand, therefore, when the fresh consideration was being made, the petitioner had already suppressed the age of superannuation. Under the peculiar facts and circumstances, this court, while not finding any fault with the disciplinary proceeding, is of the opinion that interest of justice would be served and the equity would be balanced if the relief is molded. Accordingly, it is directed that the order of dismissal is converted to one of compulsory retirement. Consequently, the authorities are directed to consider the post-retirement entitlements of the petitioner, which would be entitled after his retirement on 30/4/2022. After that, my lord, Annexure 2, page number 25, we have submitted the order through this representation before the department. And on the basis of that, Annexure 3, page 27, is the first compliance order, my lord. It is, may I read, my lord? A perusal of the order dated 14/9/2023 in WPC number 4950/2022 shows that the charge against the petitioner is of unauthorized absence. There is, however, no allegation on any materials on record that he, in his past period from 1986 till the order of attachment at Jorhat in 2004, there was any blemish in the service of the petitioner. Consideration of unblemished past service is also a relevant consideration in determining penalty against the incumbent facing a disciplinary proceedings. This court, as observed above, has been informed that the petitioner has retired from service on 30/4/2022, and therefore the question of his reinstatement will not arise at all. And in any case, the court has not come to a conclusion that the penalty imposed is grossly erroneous. The only consideration of this court is on the aspect as to whether the penalty can be converted to any other penalty, whereby the petitioner would get certain post-retirement benefits, including GPF. Considering the peculiar facts and circumstances, this is the quoted paragraph, my lord. Next, I am reading the third paragraph. Whereas just the initial order of dismissal on 12/1/2022, the petitioner has suppressed the age of superannuation on 30/4/2022. The order of dismissal was upheld by the disciplinary authority in its order dated 36/2022. When the matter was reconsidered on remand. Therefore, when the fresh consideration was being made, the petitioner had already suppressed the age of superannuation. Therefore, in compliance with the judgment passed by the Honorable Guwahati High Court dated 14/9/2023, passed in WBC number such Department of Social Justice and Empowerment has considered the conversion of the penalty of dismissal from service to that compulsory retirement with effect from 12/1/2022 and grant the post-retirement entitlements as per law. This is the correct order passed following the judgment, my lord. After that, what happened, my lord? They have issued the impugn order by modifying this order. Let me read just, my lord, Annexure 4, my lord, page 29. And that is done at the instigation of the director. Whereas the Honorable Guwahati High Court in its order dated such and such, Sri Madan Chandra Koibatya versus State of Assam and others has issued the followed directions. I am skipping, my lord. And whereas the initial order of dismissal on 12/1/2022, the petitioner suppressed the age of superannuation on 30/4/2022. And whereas the order of dismissal was upheld by the disciplinary authority in its order dated 30/6/2022, when the matter was reconsidered on remand. Therefore, when the fresh consideration was being made, the petitioner had already suppressed the age of superannuation, and whereas the Department of Social Justice and Empowerment Assam issued an order by number such and such dated 6/5/2024 in compliance with the judgment passed by the Honorable Guwahati High Court or dated 14/9/2023, passed in WBC such and such, considering the conversion of the penalty of dismissal from service to the compulsory retirement with effect from 12/1/2022 and to grant the post-retirement entitlement as per law. After taking the views of both personnel and judicial department, both the departments opined that the date of compulsory retirement should be 12/1/2022. And whereas the Director of Social Justice and Empowerment letter number such and such dated such and such requested the government for a clarification regarding the date of compulsory retirement for calculation of penalties of Sri Madan Chandra Koibatya, ex-graduate teacher, Government BDS Deep and Dumb School, presently BDS Government HS School, for hearing impaired. And whereas clarification sought from Director Social Justice and Empowerment regarding date of compulsory retirement was reprocessed and the views of Judicial Department were sought de novo. And whereas Judicial Department has re-examined the matter and is of the opinion that the order of dismissal is converted to one of the compulsory retirements as per the direction of the Honorable Guwahati High Court, the date of compulsory retirement ought to be the date of dismissal, that is 1/1/2011, which was passed by the disciplinary authority by the order dated 12/1/2022, and the department may consider the matter fresh accordingly. Now, therefore, in view of the above observation, the Department of Social Justice and Empowerment considers this to be a fit case to review the earlier order dated 6/5/2024 and directs that the date of effect of compulsory retirement in respect of Madan Chandra Koibatya be considered from 1/1/2011 instead of 12/1/2022. It is further directed that the pension of Sri Madan Chandra Koibatya be granted as per law. The earlier order is cancelled. This is the thing, my lord. Actual, my lord, now the question is from which date he will get the benefit. There are two ways. One way is, my lord, if his retirement is taken 1/1/2011, then this post-retirement benefit after that date has to be paid. And the other way is, my lord, if the date of retirement is taken as per this 12/1/2022, then, my lord, his post of retirement should be given from this day, following date, by treating the gap period. That gap period has to be treated as either as regularized or as, my lord, his salary has to be calculated. He cannot be given the pension of 2011 in the year 2022 because his department is trying to pay his pension of 2011 in the year 2022. That is the thing, my lord.
The direction of this court was to grant him retirement benefit with effect from 30th/4/2022.
Yes. That is there, but they are modifying it.
Whether you have filed any review petition before.
Lordship may kindly peruse order dated 23/6/25, passed by Honorable Justice Q K Nair. There, everything is reflected, and I have produced one record also. It's been marked as X and keeping that record.
This number, order dated.
23/6/25. There, Honorable Justice Q K Nair has marked the record as X.
Even 23.
23/6/25.
itu খালি বেলেগ হৈ দিয়া নাই খালি instruction দিছিল instruction কেনে দিয়া আছে দিয়া নাই ইহু
No, what was the direction of this court?
Lordship. The direction of this court is already been reflected in that order, in that instructions, Lordship. May I read, Lordship? In the second page, the court while not finding any fault on the disciplinary proceeding is of the opinion that interest of justice would be served and the equity would be balanced. If the relief is molded, accordingly, it is directed that the order of dismissal be converted to one of the compulsory retirement. Consequently, the authorities are directed to consider the post-retirement entitlement of the petitioner, which should be entitled after his retirement on 30/4/22. The court also opined that the present case is not to be treated as a precedent for other cases. Lordship, if Lordship peruse first page of the instructions, Lordship, that is first, second, third, fourth line. Sri Madan Chandra Koibato stated in his own statement that he was absent from 1/8/2007 to 30/12/2008. That is Annexer E. His own statement has been annexed. However, he joined on 22/4/2010 and served till December 2010. Further, he was continuously absent from December 2010 without the approval of the authority. That is Annexer F. He was continuously absent, Lordship, without any approval, and his absence was not being regularized also. because of which,
All right, but whether the direction of this court is complied with
yes, Lordship, it's been complied with. Lordship.
and thereafter reviewed.
Yes, yes, it's being reviewed. It's being reviewed by the judicial department, Lordship. That is written in the.
Whether
in-
judicial department is the appellate authority of this court.
No, no, not like that, Lordship.
Then?
It's being written that where is judicial, that is, if Lordship peruse annexer L.
No, you, Mr. Das, you tell me whether you were to follow the order of this court or the judicial department.
Lordship,
Is the judicial department is a appellate authority of this court or reviewing authority of this court?
no, judicial department is not
Then?
about this honorable court. Lordship.
Then you have modified the order on the basis of the opinion given by the judicial department.
Lordship.
So judicial department is the appellate authority or reviewing authority of this court.
Not like that, Lordship.
Then
Then I have to take the instructions why this order has been carried out.
hmm? Why we should not register a suo motu contempt case against against this person who has reviewed this order?
Lordship,
Why should not we register a case against him?
Lordship may give me a quick time, Lordship, so that I can get the clarification from the concerned person why this view has been taken from the judicial department. Lordship. Because without instructions, it becomes on my part to address this honorable court.
No, you tell me whether you are the reviewing authority or appellate authority of this court. While there was clear direction of this court, once you have complied with it and later on reviewed the same. By tomorrow, you have to obtain inspection.
Lordship, I will.
Otherwise, we will proceed against it.
Yes.
Heard Mr. B. Purkels, learned counsel for the petition. Mr. R.M. Das, learned counsel for the respondent. Place the matter tomorrow at 2 p.m. So as to enable Mr. R.M. Das, learned standing counsel for the respondent authorities to obtain inspection.
Lordship, wait a minute.
Matter is started.
Tomorrow at 2 p.m.
10.
Recessal is the matter is started.
Obliged.
17th, I have received my instruction. I will file the affidavit, Lordship, within a week, Lordship. I have already informed my learned counsel, Lordship.
The date may be given, it's pending for 2022, my lord.
Only a week.
So after 1 week, date may be given, my lord.
Heard Ms. Ardotto, learned counsel for the petitioner. And Mr. S.M.P. Sisti, learned standing counsel for the respondent, secretary to the department. So Sisti submits that he has received inspection. And he will bring on the record the said inspection by filing an affidavit. And he press for listing the matter after a week. Fair allowed, places and list the matter
On 17 November,
Obliged.
Leave lovely.
on 14 November,
14.
14 November. Item 18,
Need to pleases you, lordship. Kindly grant us 2 weeks' time, your lordship, to
Week-
obtain instruction, to obtain instruction.
So you have already been granted several weeks.
Your lordship, instruction, I said. One instruction has received right now, your lordship. Your lordship kindly, they mentioned that as per written submitted by the petitioner, that is Srimati Beena Das, wife of late Jitendra Kumar Das, teacher of Ponton ME School under BEO Soigaon, the service of late Jitendra Kumar Das was submitted to your esteemed office in the year of 2012. As per the direction, it was
You
reconstructed.
do one,
The service book was
you-
needed to be reconstructed, your lordship.
you forward the instruction to the courtmaster and also furnish a copy to him. We'll take it up after some time.
Your lordship, here your lordship, that.
Item 19,
May it please your lordship. My lord, this matter is regarding, my lord, in charge of a higher secondary school, my lord. And the petitioner before your lordship is the senior most assistant teacher, having all the requisite qualification to be the principal, my lord. And the post of principal has been fallen vacant, and thereafter, my lord, the in charge was given to the, my lord, junior person, my lord, junior most person. So precisely, my, that's my grievances. Since I am having the all the deserving qualifications, my lord, more than 33 years experience and post-graduation having B.Ed degree, my lord. And my lord, instead of that, my lord, was given to the private respondent, my lord, the academic charge was given to the private respondent who is much more junior than to me in all respect. From the point of age, from the point of retirement, from the point of appointment, joining, everything, my lord. That is one aspect. And second aspect, my lord, the overall in charge, my lord, that is given to the inspector of schools, my lord, Nagaon, my lord. And that, my lord, will find page at page 29.
Yes.
And my lord, I made a statement in oath, my lord. Since I am the deserving, my lord, I am the senior person, I am entitled to get the same. And it was given to the another person and waited I for some time. And thereafter that man is also retired. And I was expecting that it will be given to me. But in one fine morning, my lord, it was given to the inspector of schools, my lord. That is page 29. And this inspector of schools, my lord, he is the in charge of as many as 20 plus schools, my lord, in Nagaon district as well as the Morigao, the Huzai district, my lord. In Huzai district and Morigao district, this inspector, he is having the holding charge of in charge of all the higher secondary schools. I don't know, my lord, why. Deserving persons are there, senior most teachers are there, no anybody, nothing of the sort. And it was to be given, my lord, to. And instead of, he is the senior inspector of schools, he himself is a important fellow, my lord, in the district. He is having a lot of, my lord, the duties and obligations of his own office, my lord. And in spite of that, my lord, not only 1, 2, 3, 4, my lord, around 20 schools, my lord. I don't know why. And that page 29. So I have challenged it. And secondly, since he is overburdened, that is why the academic charge is given to the, my lord, junior person. Even the academic charge, my lord, that's I am entitled, my lord. And it was not given to me. Last page, my lord. It was given to the private respondent. Last page, my lord. Therefore, my lord, my prayer before your lordship is this, my lord. Since I am deserving, my lord, I am fulfill all the criteria, my lord. I should be given. And for last, my lord, 1.5 years, I have been fighting here. And till now, my lord, no regular principal has been appointed. Till now, 1.5 years have gone by after filing of the writ petition. So, my lord, these two order, my lord, should go, my lord. And man, let me get it. And the moment when the regular principal will come, I will have to quit. I will have to go.
Yeah, I have received my instruction, Lordship. So, here, Lordship, may kindly peruse the Assam Secondary Education Confederation School Service Rules 2018, Rule 12, Sub-Rule 3, 5, page 32 of this book. Page 32.
Page 30?
32. Rule 12, Lordship.
Yes.
Recruitment to the principal and procedure thereof. Sub-Rule 3, 5, Lordship. The age of the candidate must not be more than 57 years as on the 1st January of the year of recruitment, provided that the service teaching experience acquired in a school during a consideration period shall be counted. that a person who is eligible for a post of principal, he should not be more than 57 years of age. And my instruction is that Lordship, can you peruse the instruction, Lordship? Bullet point 3. As per the senator list, Muhammad Sheikh Abdullah's date of birth is 1/6/1967. Hence, on 1/1/2025, his age is 57 years, 7 months. Bullet point 4, Lordship. It is pertinent to mention here that as per Rule 12.3.5 of the Assam Secondary Education So-and-so Rule 18, the age of the candidate must not be more than 57 years as on the 1st January of year of the recruitment. So in this regard, I like to file my affidavit in this case, bringing all these facts, Lordship. He is not entitled for the post of interest. And moreover, we have already started the process for regular selection only because some court cases it is stopped for the time being, Lordship. Otherwise, and that so far as the inspector of school is concerned, it is the his submission he is overburdened. Inspector of school he may not be overburdened, Lordship. He is functioning all the schools properly. That instruction I have to take. I want to bring everything on record, Lordship, within a week. So this is the rule doesn't permit that he for his entitlement to the post of principal.
On that day, my lord, I am a-
Principal, whether in.
Insert regular are,
So this.
yes, yeah, for insert and for regular, the eligibility criteria is same, Lordship. Qualification and other criteria are same.
Those are not disputed, my lord. Those are not disputed. So for the other qualification, everything, my lord, there is no dispute, my lord. It is rather admitted. But so far the age part is concerned, my lord, at the relevant point of time, my lord, I was entitled. I am within time, my lord. Now with the ages of the passage of time, pending of this writ petition, my lord, they are going to make it in fact so taking time. So anyway, my lord, last chance may be given so that, my lord, and short date, my lord. Otherwise, it will be in fact so, my lord.
Mr. Learned Senior Counsel assisted by Mr.
R. Varua.
Learned Counsel for the petitioner. Mr. S. M. Learned Content Counsel for the Responsibility Secretary Education Department. Mr. Sisti has, Mr. Sisti submits that he has his instruction and he will bring the same on record by Friday and affidavit in opposition and price for granting in 1 week time. They are allowed to raise the matter on 10th of November. 10th.
Obliged, yes, I'll file it within a week. Yep.
10th of November. There's last opportunity to
Yes,
file
yes.
the.
Highly obliged.
Item numbers 20 and 21.
By Friday, thank you for everything.
May it please your lordship. Herein to lordship, they have sought time on 6 occasions, but the affidavit has not yet been filed, lordship. And it is with respect to the upgradation of the teachers from the category of tutors to teachers, lordship. They should have been appointed as teachers, but they were appointed as tutors. The documentation shows that the process is ongoing within the department, lordship, but no affidavit has been filed yet. 6 occasions. On 14/7/2025, lordship, Honorable Justice Nair indicated that on the next date, invariably the affidavit has to be filed. But they again sought time on 2 occasions.
Who is appearing for the respondent authorities? Elementary education? Okay.
Much obliged.
Item 22.
Maybe. In this case, my lord, UGC, whether that issue is there regarding আমি আরম্ভ করে আইব
Okay, so. Yeah, wait for some time. Court master will inform.
23.
May I please? In this case, my lord, the petitioner petitioner's SCR, my lord, has been degraded without giving him an opportunity of being heard. This is the core issue, my lord. He is in the SCR reviewing authority as well as the accepting authority degraded his grade from, I'm taking your lordship, my lord. Annexure 1, my lord, page number 21. This is the notification which regulates the, my lord, mode and manner of promotion to the post of, my lord, the joint director under the Assam Education Service Rules 1982. This, as per this notification, my lord, your lordship will
No,
find.
your contention is that without giving an opportunity of being heard to you,
Yes,
you have been downgraded
yes.
from,
Downgraded, my lord, in the SCR remarks.
yeah,
From excellent to very good to good, that they have degraded.
from who is grade?
My lord, in one SCR in excellent is to, it has come to good only. And I'll take a lordship.
So whether the rule provides for
Yes,
informing you.
yes,
hearing
yes.
you,
Rule provides that one should be given an opportunity of being heard.
where?
If the accepting authority or the, my lord, the reviewing authority degrades.
Where is that rule?
Rule 10 I'm giving. I've annexed the rule, my lord. I'm coming to annex, entire rule is annexed here. I'm coming to that, my lord. Rule 10,
Page number?
page 59. Where a confidential report of an employee contains an adverse or critical remarks, it shall be communicated to him by the reviewing officer in writing together with a substance of entire confidential.
Whether it was communicated to you.
No. That is the case, my lord.
Are you sure?
Yes, 100%.
In which paragraph of your petition you have mentioned it?
Yes, that's I'm giving.
Para number?
Yes, I'm giving. There are 5 yellows will find. Page 8. That having come to know that the candidature of the petitioner has been rejected by the DPC, the petitioner has filed an RTI application dated 31/7/2024 before the state respondent, whereby the petitioner has asked for the copies of the SCR of the petitioner and the incumbents who have been promoted to the post of junior director. However, the said application has been rejected by the SPIO by the communication director, and accordingly the petitioner has preferred an RTI appeal dated such and such. Thereafter, a hearing notice has been issued by letter dated such and such, and the petitioner appeared in the hearing on such and such date, and thereafter state respondents had provided the copies of the SCR of the petitioner for the year such and such, but the copies of the SCR of other incumbents have not been provided on account of third-party information. On receipt of the SCR, the petitioner has found that the reviewing authority and the accepting authority has degraded the remarks from excellent to very good, and then very good to good. The said degradation in the SCR has to be intimated to the petitioner, and he ought to have been given an opportunity to submit his representation in support of his claim as per the provisions of the Assam Services Confidential Rules 1990. Therefore, the petitioner has again submitted another RTI application dated such and such before the office of the respondent, asking for the copies of the DPC proceedings and the merit list awarding marks. The SPIO by this communication such and such has provided the copy of the DPC minus, but the claim for remarks awarded by the DPC has been rejected on account of third-party information, whereas the petitioner himself was one of the candidates in the merit list prepared by the DPC.
And now come to the rule.
Yes, rule page 59, my lord.
Hmm.
Whereas the confidential report of an employee contains an adverse or critical remark, it shall be communicated to him by the reviewing officer in writing, together with a substance of entire confidential report, ordinarily within 1 month of its acceptance by the accepting authority, when all the three authorities are in the same station. When the three authorities in different stations, the communication of adverse remarks may be made by the controlling officer, head of the office, after acceptance of the report. In either case, a certificate to the effect that the adverse remarks has been communicated to the person connected shall be recorded in the annual confidential report before it is sent to safe custody.
Mr. Sharma, you have filed your affidavit here?
Yes, they filed, I filed the reply, my lord. In the affidavit,
How this
in the,
petition made in the paragraph number 5 of the petition is dealt?
Yes.
they are
Against the petitioner, against the paragraph number 5, we have stated that as requested by the petitioner, filed RTI appeal number so and so, and RTI application dated so and so, the Department of School Education provided the copies of ACR, ACR of the, my lord, page 69.
Got it.
Yes. ACR of the petitioner for the year 2019, 20, 2020, 21, 21, 22, 22, 23, and 23, 24, as well as the copies of minutes of the selection board meeting held on 26/7/2024. But the copies of ACR of other incumbents and the marks awarded by the selection board have not been provided to the petitioner on account of third-party information. As regards the declaration of petitioner's ACR by the reviewing and accepting authority, it may be stated that there is no such provision of Assam Service Confidential Rules, Rules on 1990, that the declaration in the ACR has to be intimated to the employees concerned, and he ought to have been given an opportunity to submit representation in support of their claims. However, in a rule 10 of.
Sir, Sharma, there is a decision of Supreme Court in
yes,
Devadatta case?
I'm giving my lord. In our case, our court has the order, my lord. Your lordship will find page, I'm annexed also. The annexer 12, page 62. And your lordship, that in that case, all the decisions of Supreme Court and quoted. And paragraph 9, my lord, page 65. What is it? What is it? Paragraph 9, page 65. From the what has stated here in above, it only appears that the respondent authorities failed to adhere to their own guidelines. The fact and issues involved in such and such case cited by the learned counsel for the petitioner is found to be similar. Relevant portion of the said order, which in paragraph 9 and 10 is quoted herein below for perusal. It is well settled that any entry in the ACR, whether good or bad or adverse, are required to be fully communicated to the concerned employee. As the entry in the ACR resulted in the denial of promotion to the petitioner, it was a bounden duty of the respondent authorities to communicate the adverse entry in the ACR to the petitioner. The said adverse entry in the ACR having been not communicated, the court.
Okay, Mr. Sharma.
Yes, ma'am.
So it appears from your affidavit that you have not communicated the remarks in the ACR to the petitioner, right?
Regarding that, my lord, here in the first paragraph of paragraph number 5, it is stated that the petitioner filed RTI appeal number so and so, and RTI application, the Department of School provide the copies of ACR. ACR of the petitioner so and so years, the copies of minutes of
You
the.
have provided the copy pursuant to the application filed by him under RTI Act.
Yes, ma'am.
But you have not communicated the remarks in the ACR to him. Not communicate. Okay, we will dispose of this.
My lord, my humble submission is that my lord, he may be given retrospective benefit. My lord, already his juniors and others been promoted, and due to less mark in the, my lord, SCR, he was not given the benefit, my lord. He was
Let us,
dropped.
we'll see.
Yes, okay. Yeah, and one post is already stayed, interim order is there, my lord. Obliged.
Item number 24.
Lordships, here I have received instruction, will file our affidavit and let it fix along with on 11 Lordship, the other item 42, no, 42, no. Item 11, on 11 Lordship, the same council Lordship of the same method, almost the same method Lordship. We'll file here.
Detail order on 15/9/2025. So which means there.
Along with item 41 was fixed on 11 Lordship. This matter may also can fix on 11, we will file the affidavit in the meantime.
Item number 11 is defined from this one.
No, council is same, will be able to file our good matter together Lordship.
Okay, all right. Third, Mr. Gogoi, learned counsel for the petitioner, pending counsel for the respondent authorities. Mr. Sisti submits that he has received inspection and he will bring up or the said inspection by filing an affidavit in opposition. Then he tries for listing the matter on. When?
11 Lordship.
10.
11.
11. There alone, this is a list of matter on 11.
Obliged.
25.
My lord, here, my lord.
Kindly 2 days time may be allowed to move matter. Can you, I have not received the instruction matter to get the
You have-
approval of the director matter. Matter may be taken on Friday, my lord.
No, my lord, I have urgency, my lord. I have been,
Wednesday, my lord.
my lord, even they are issuing also during the pendency, another letter has been issued just to harass the petitioner, my lord. My suspension is illegal. It is apparent on the, this is the violation of rule, my lord. They are, my lord, harassing me, my lord, nothing else. No order was communicated to me. Even rule 6 says, if they are, rule says that he is
But-
not authority, my lord.
So during the pendency of this petition, what letter they have issued to you?
They have issued, my lord, on 27 to hand over the search, my lord, during the pendency, when the matter is fixed for interim order, consideration of interim order. My lord, this letter has been issued during when my lord asked, fix the matter for considering interim order. And I have filed a petition seeking 1 week time, but they have treated very badly, my lord, me. Being a teacher, 56 years, my lord. Even my lord threatened me to stop my substantial allowance also, my lord. My lord, they are very illegally doing it, my lord.
So let her file affidavit on Wednesday is holiday. On Thursday.
Thursday.
Thursday. Art Mr. Kundaker, learned counsel for the petition of Miss. And spoken learned standing counsel for the respondent. Department. Spoken submits that the matter may be listed on Thursday. So as to enable her to file her affidavit. Where is the law? There's a list the matter on Thursday.
For motion, my lord.
Motion.
For motion. And my lord, till then, my lord, in terms of this letter, no coercive action be taken place. My lord, otherwise they will, today they are doing anything else, my lord. Today, my lord, they may do anything, my lord.
No,
I have-
Mr. Khandokar, this is not a motion matter. This is
This is
No, my lord.
admission matter.
Notice has not been issued. Only instruction was sought for because I have urgency. No notice was issued.
Then you are representing all the respondents.
My lord, kindly peruse the last order. My lord's order. Only instruction was sought for.
No, my lord. I am appearing on behalf of only 1 to 5 matter.
This cluster resource coordinator.
No, my lord, I'm.
He is the CS.
He's
He
a
has been,
teacher, professor.
my lord. My lord, my lord, I have submitted an application seeking time today only, my lord. If today no order is passed, my lord, they may take coercive action. In terms of 2710 letter, my lord, I have submitted only,
Mr. Khandekar, you see, by producing a letter this way, interim order cannot be passed.
because my lord, the order is, it cannot be stand for a moment, my lord. Violation of rule, my lord. He has no authority to suspend me. He is not the authority, my lord. Rule says, my lord, my kindly see. No, my lord, I am, my lord, they are, I am suspended and they are during the pendency, my lord, they may do anything if not state, my lord. If the order is not state. My lord, the violation of section rule, clear violation.
Has
Has approved.
given approval or not, that instruction not available with me, that's why
But,
I'm
my lord,
asking for today's timeline.
no, last occasion, my lord, they have been given time. My lord,
No,
they may try,
Mr. Khandekar, wait till Thursday. That
Thursday,
file our
till
application.
my only prayer, my lord,
On
till
that
then,
day, we will consider your interim prayer.
my today only prayer, till then the in terms of 27 letter, my lord.
No, this letter is not part of the record.
My lord, but I have, they submitted,
Then
they
you
send,
file an IA or additional affidavit bringing on record this letter.
my lord, only thing is that status quo only, my lord, otherwise they may do anything, my lord. If I sought till today time by this application, my lord, mildly peruse my application.
Madam, you instruct the.
Otherwise, they may
the
take
education
some
officer
coercive
to
action.
Take any action.
I have not seen whether.
If not, if taken, my
Furnish
lord,
a
I will
copy to
suffer,
us.
my lord.
Furnish a copy to. This is the matter on Thursday.
Cross the line.
Interim care of the petitioner will be considered on that day.
Hi, developed.
I'm the.
Timing matters. Item number 4 for motion.
Made Pijalov. My lord, the matter, the issue is whether the BF certificate of the petitioner is valid. Because depending on that, my lord, the other consequences will follow. Now, my lord, the impugn order, if a lordship kindly comes to, now what has happened? Now, because they have some doubt about my BA degree, now, my lord, there are three charge sheets has been issued. Well, it's a different matter that three charge sheet cannot be issued. Now, assuming, my lord, there is some doubt regarding my BA degree, where is the scope to place me under suspect? Is it a misconduct, my lord? On the contrary, when the director of higher education wrote to the university, please come to me, lord.
Now you are under suspension.
Yes, now I am under suspension. But I'm I'm at a loss to find out why I have been suspended. One, why my lord DP is initiated against me? Is it not a misuse of authority, my lord? Kindly see, basic issue is, if your lordship would kindly come to page number 56. This was a letter written by director to the Millard University. Because they have some doubt, therefore they wrote it. In inviting a reference to this office letter mentioned under reference, I would like to inform you that this office is in urgent need of information in connection with verification of
professional qualification of incumbent concerned, and same has not yet been received from your end till date. You are therefore requested to kindly clarify authenticity, genuinity of this certificate and mark sheet of PhD degree of Zaharul Islam, which has been awarded from Magadha University under registration number so and so. If a lordship would kindly come to the next page. This refers to PhD certificate of Sri so and so, PhD topic so and so with reference to so and so. This PhD certificate have been verified and found to be genuine and correct as per the official records of the Magadha University. So what is there, my lord? Actually, why they doubted, my lord, that the course was not done because the university adopted the 2009 UGC regulation subsequently. Those also we have annexed. Now, in this circumstance, where is the scope of placing me under suspension and issuing one show cause notice after another? 3 show cause notices has been issued. What is the misconduct? Well, misconduct is defined. It cannot be on the basis of exceed of some authority, my lord. Now, if your lordship will kindly come to, I'll just show, my lord, why this is a genuine. Now, page 38, my lord. The undersigned candidate has been permitted to get himself registered for PhD subject to acceptance of the conditions as laid down in the regulation. Now name so and so, address, enrollment number, term so and so, so and so. Then, my lord, please come to page number 40. I am directed to inform you that you have been allowed retrospective registration from second so and so instead of so and so for submission of PhD thesis. Then, my lord, will kindly come to page number 41, but the relevant portion is at page 42, clause 7 on top. PhD course shall be of minimum 2 years and minimum 2 years and maximum 4 years. It should be maximum, my lord, for general research students and 6 years for teachers. Provided also that a teacher having 3-year teaching experience may submit his thesis just after registration, that is retrospective registration up to 6 term may be given by Vice Chancellor in the case of teacher who have at least 3 years teaching experience. So these provisions are there. Then eventually, my lord, if your lordship would kindly come to page number 47, this was issued by the Governor Secretariat of Bihar. This is a communication to all Vice Chancellor. I am directed to invite a reference to the subject noted above and to say that Honorable Chancellor, after due consideration of Uniform Ordinance and regulation governing award of PhD degree by Universities of Bihar, prepared and recommended by University Advisory Committee, in the light of the UGC guidelines by notification dated so and so, and Bihar letter dated so and approved by statutory bodies of the university, is pleased to accord assent to the same in exercise of the power vested in him under Section 38(4) and 39(2)(2) of the Patna University and Bihar State Universities Act. Then, my lord, will kindly come to page 49. Now, this was for the first time, my lord. 2009 regulation was adopted. Pursuant to the decision of meeting of syndicate dated so and so, and decision of the Academic Council by agenda number 11, enclosed, Uniform Ordinance and regulation governing award of PhD degree by State Universities of Bihar, circulated by Governor Secretariat letter dated so and so, in the light of the UGC regulation of 2009, for registration for award of PhD degree already approved by the Academic Council and syndicate is implemented forthwith. So only on 21/2014, my lord, that the UGC regulation of 2009 was, adopted. And the coursework, which is envisaged in 2009, came to be applicable only from 21/2014, whereas the petitioner got his a PhD degree before that. Now, on the face of these materials, doubting my PhD degree, placing me under suspension, continuing with the disciplinary proceeding, in my humble submission, my lord, it is absolutely arbitrary and unwarranted. And finally, my lord, if your lordship would kindly come to page 53, this is a public notice issued by the UGC itself. Page 53, my lord.
Yes.
UGC has been receiving queries from various stakeholders, universities, seeking clarification with regard to definition of the word regular mode. Oh, I'm sorry, I think, my lord.
No, all right, you
Yes,
complete.
yes. The commission at its meeting held on 22nd of February 2017 considered the issue and decided that it may be read as under. PhD degrees which are pursued either full-time or part-time will be treated as degrees awarded through regular mode, provided these are in conformity with the existing statute, bylaw, ordinance, etc. of the degree awarding university. However, PhD acquired under distance mode is not permitted. So, if the award of the PhD degree is in accordance with the statute of the university, then it is okay. So, I got it under the Bihar University Act. That coursework was not included then. Now, in such a scenario, my lord, to doubt my credentials and to initiate a disciplinary proceeding with great respect, I'll submit, my lord. It warrants interference by your lordship. At least suspension, my lord, why? What is my misconduct? How can we establish that my degree is fake when the university which has given it says no, it is all right? Or unless there is a declaration by some court of law. Who has questioned my degree in a court of law? Nobody.
Okay.
That's my humble submission.
Will resume after 5 minutes.
Yes. People, at the motion stage, it was hard. That is why it has now again come up as motion. It's a matter of 24 million. Anyway, there are 2-3 other aspects, Milord. If a lordship would their main concern of the government of Assam was that I have not done coursework.
Not that?
Coursework. Because under the 2009 regulation, there is a requirement of doing coursework. Now, the university's regulation itself says, Milord, it was not required before 2014. If your lordship would kindly come to page 58. It was again written by University to the Director Higher Education. Page 58, Annexure 14. This is to inform you that teachers of the university and college holding their post permanently in the colleges are affiliated by State University Association of Indian Universities, eligible for registration for PhD without appearing the PRT test up to 2014, because 2014 is the date when they adopted. It is also noted that above mentioned teachers are exempted from coursework. Now, coursework is now, my lord, made mandatory after 2009 regulation. Now, kindly see, my lord, the stand of the university. Sorry, UGC. If you're, it's an affidavit filed in an earlier litigation at page 90. The four line from bottom. However, it is Magad University who can categorically place a reply to address this issue as to how the petitioner was awarded PhD degree without attending coursework in Magad University. So, university stand is also very clear. I have already placed that, my lord, notification of UGC, which says it will be regulated by the statute of the university. Then, my lord, will kindly come to page number 102. That is my reinstatement order at page 102.
Yes.
In compliance of the order of the Honorable Guwahati High Court, passed in so-and-so and in so-and-so, Sri Jaharul Islam, Principal of Rajiv Gandhi Memorial College, Lengtisinga, Bongaigaon, who was placed under suspension by this office order for doubtful PhD obtained from Magad University, is hereby reinstated in his service with immediate effect, subject to outcome of report of inquiry committee constituted by the government dated so-and-so. So, my lord, it's not that only Magad University, there were cases from quite some other universities where, my lord, without coursework, the PhD degree was obtained. So, my lord, now the committee's report is out. Now the committee has found, they haven't found anything wrong with the Magad University. এখন লিখে থাক। এখন UGC ঢুকুন। I'm sorry, sir, এখন নয়, এখন নয়। হ্যাঁ, পাবলিক নোটিস? না, আসাম এখন দেখ। কবে? Did you do it, please? Now kindly see, my lord, first the public notice was issued by UGC. It names OPJ University, Suru, Rajasthan, Sunrise University, Alwar, Rajasthan, Singhana University, Rajasthan. Then please come to the Assam government's report. This is the report of the committee, my lord. Non-acceptance of PhD degree awarded by these three universities for condition withdrawal of regular provincial upgradation of service or for direct recruitment to any post. Now, my lord, the public notice issued by UGC is quoted in the first part. Please come to the second paragraph. In second paragraph of the above referred public notice, it is clearly stated that three universities did not follow the provisions of UGC PhD regulation and also academic norms for award of PhD degrees. Therefore, due to non-compliance with UGC PhD regulation and academic norm, PhD degrees awarded from above three universities cannot be accepted by Higher Education Department, Government of Assam for any condition, withdrawal of regularization, upgradation of service, etc., etc., for any direct recruitment to the post of principal, assistant professor, etc. So, my lord, only in respect of these three universities, the committee found that there are irregularities. In respect of Magad University, my lord, there is none. So, therefore, my lord, the continuance of this proceeding, in my humble submission, is an abuse of the process of law authority, my lord. Therefore, pending further orders, lordship will stay the proceeding, or at least our lordship will direct that they will not take any final action pursuant to the proceeding, my lord. Or they will take leave of.
Can we finally dispose of the matter?
Yes, it can be, my lord. Can be. And that is my submission, my lord. I don't have any further submission to make. Even UGC also made his position very clear that it will depend upon the relevant statute of the governing university.
Notice has not yet gone.
Notice has gone.
Earlier it was heard.
It is heard, but nobody has responded yet. So, well, for the ends of justice, at least for the principles of natural justice, we should be allowed to file our affidavit at least. Number one. Number two, in this same person litigated earlier, and we made our stand clear. My lord, it is not, it is on record, my lord. I can show from the record of a different case called Dr. Lukman Ali. This honorable court was pleased to pass an order directing UGC to make a thorough inquiry whether the PhD degree was for that person is true or not. In that person also annex these kinds of documents showing every clarity. But later on, when the officers from the UGC registered, UGC appointed a registrar of a different university to make an inquiry, everything was found false. Therefore, my lord, in my respectful submission, to protect the sanctity of a degree, at least, my lord, give us some time, or if lordship pleases find out, to make an order, pass an order kindly, directing the UGC to make a thorough inquiry. Well, at Magadh University, CMJ University, Jhunjhunu, Rajasthan, this Singhania University, these are the most unscrupulous universities, my lord. They have flooded degrees like anything. Morning you pay 2 lakhs rupees, in the evening one can get a PhD degree certificate. my lord. These things are going on. Therefore, my lord, my respectful submission, if lordship considers is appropriate, pass the direction, my lord. UGC Suomoto cannot do, that is the problem.
No, that's all right. We'll pass this order at the final stage.
My lord,
We are not going to dispose of the petition today then.
my correct, my lord, correct.
Yeah.
That is why, before disposal, my lord, if lordship pleases to direct us, to make an inquiry and find out what is the fact, then my lord, perhaps this will help to adjudicate this matter. That is the only plan. In the meantime, my lord, government will also respond.
I mean, look, if they want to file an affidavit, I have got no objection, my lord. But prima facie, my lord, what is the material to proceed against me? So therefore, the DP which they are conducting, they should not pass any final order. That's my interim prayer, my lord. They should not take any final action in the DP. Tomorrow they might dismiss me also, my lord.
Done, but lordship will fix a date. By the time we will come back with a report.
Yes, yes.
Lordship may direct us for a UGC to make a thorough inquiry on the ground. In the meantime, to protect my Leonard Senior's client,
No. For inquiry, if necessary, we'll pass in the final order.
You file your affidavit.
no, my lord, after the inquiry, if we file an affidavit and produce this report through an affidavit, that would be perhaps better in my respectful sir.
No.
After all, what lordship subject to, what lordship comes from your lordship. Because that inquiry will navigate the adjudication process. The core issue is that whether the degree is valid or not. There are instances in our High Court directing the UGC to, I can show this, Dr. Lokman Ali, if give me 5 minutes time, I will find out the orders.
Lokman Ali Kolpa Paisi.
Magadh University, same university. This is the most unscrupulous university.
Don't use that word.
State university, that is why it cannot be, my lord, eradicated, but delisted. My lord, there are chances that these records are not there in the office, in the office of the registrar of the university. If somebody goes in particularly to see the records. In that case, Lokman Ali, there were also several communications from the Magadh University signing under the signature of a registrar, which says that these are valid, so and so, so and so, so and so. Later on, when somebody goes there and find out everything, there's nothing. There are possibilities. I'm not saying that this case, but there are possibilities. So I leave it to your lordship's wisdom, my lord. If we do an inquiry and come back with the report, filing with it and an affidavit, this will help in adjudication.
Can you do it within a short period?
Yes. 30 days time is enough. 4 weeks time is enough. Just 1 or 2-day visit will suffice, my lord.
Yes, so what is your stand, Mr. Das?
My lord, this inquiry has been conducted pursuant to court orders, my lord. My lord, kindly have first page 98, my lord.
Page number 90.
97, my lord. The petitioner has earlier challenged one focus notice, my lord. The second focus notice actually. No, he challenged the suspension order, my lord. Page 98, my lord. Here, the para to the case of the petitioner is that he was placed on the suspension by order suspension. This was challenged, my lord. Then, my lord, kindly have para 3. On 3/6/2017, this is the, my lord, focus notice pursuant to which this DP has been initiated. On 3/6/2017, focus notice was issued to the petitioner along with statement of allegation, etc., which is claimed to be served on him on so and so, and by separate order by so and so, the then Deputy Director of Higher Education Department was appointed as inquiry officer. This claim that till the date of filing of the writ petition, neither any inquiry was conducted nor any departmental proceeding has taken place. It is also submitted by the learned general counsel for the petitioner that in the meantime the petitioner has submitted a show cause reply so and so. Then my lord, kindly come to page 101, para 14.
Yes.
Order shall not be a bar for the respondent of my lord, by way of this order, this suspension was my lord, set aside and petitioner was department was directed to reinstate the petitioner. Then this observation came from this honorable court that this order shall not be a bar for the respondent authority, especially the respondent number 2, to proceed with and conclude the departmental proceeding initiated against the petitioner, which is pending since the year 2017. Then it is said that it is hoped that the respondent number 2 will bring conclusion in within 2 months, my lord. So, my lord, by way of this order, the court has directed, court says that there is no bar for the respondent authority to proceed with the departmental proceeding, which is, my lord, under challenge in this writ petition. Then, my lord, kindly come to page 116. Petitioner was served with a third show cause notice also that was put to challenge by way of this writ petition 430724. This writ petition is still pending, my lord. 116, the policy part will be 117. Second last para, my lord, here. In the interim, the show cause notice that was so and so, that was the third show cause notice issued by the Director of Education Assam and order that is so and so issued by the Director of Education shall remain suspended till the next reasonable date. Then, however, it is made clear that the disciplinary proceeding initiated pursuant to show cause notice stated so and so is not interfered with. This is the disciplinary proceeding which is under put to challenge by way of this writ petition. So my humble submission would be, my lord, since these two orders has not been put to challenge and is still operating, my lord, this court at this stage, my lord, shall not interfere with the departmental proceeding because otherwise, my lord, this will be exercising of appellate jurisdiction, my lord, while this orders is still in force. And kindly have the show cause notice, my lord. So not show cause, my lord, page 118, my lord. Whereby that authority has appointed inquiry officer, my lord, in page 118, next page. In compliance of the Honorable High Court's order dated 28/8/2024, passed in WPC number 4307. This is the order which I have already showed, my lord. In compliance of that order and in exercise of power conferred under Rule 9 of Assam Civil Service Discipline Rules, appointing authority was conducted, my lord. So at this step, my lord, let's notice we go. And as my learned friend has rightly said, my lord, this dispute has to be looked into by the inquiry authority, my lord. And what is the prejudice will cause to the petitioner, my lord? His role is to participate in the disciplinary proceeding. Then disciplinary proceeding will take a decision at by that time, my lord. Let this my lord, report. Yes, my lord. In the meantime, as my lord friend is suggested, my lord, so let this report be come and we'll place everything in a affidavit, detailed affidavit, my lord. But at this step, let DP shall not be state, my lord. Let the DP go. Let the DP go, my lord. Nothing prejudice will happen, my lord. Only the role of the petitioner is to participate in the DP. Nothing will happen in 1 or 2 days, my lord. Not in 2-3 months.
Finish in 1 month.
And my lord, this DP was initiated in the year 2017, my lord. Since then, the petitioner has not challenged the DP till filing of this my lord, writ petition. And in the meantime, by way of 2 orders in 2 writ petitions, the court has directed the authority to proceed with the DP. That is my humble submission.
The first order is at page number
First order is at page number 97, my lord. Next at 28. I'll be relying on para 3 and para 14. Here, the petitioner challenges the suspension order, and pursuant to that, he was reinstated, my lord. While setting aside the suspension order, court says that you proceed with the DP. Then, my lord, the second order is
Okay, got it.
the second order is
Just
my lord,
sorry,
116.
in view of these two orders, can we stay the departmental?
No, I'm not saying for stay, my lord. I never said that stay. I said they will not finalize it. They will not finalize it. Lord will kindly see, here is a case, my basic contention is what is the misconduct I have committed. I have obtained PhD degree from a particular university. Now university is doubting that because the course curriculum do not include coursework. Now, my lord, the university has clarified, UGC has clarified. I do not know, my learned friend, few minutes back, he said, if departmental proceeding is stayed, he said he has no objection. My friend, Mr. Anyway, now the question is, my lord, Supreme Court grants bail because there is no speedy trial. Why? Otherwise, a person charged under NDPS Act and all, they can be kept in detention for longer period. At the end of the day, my lord, this justice delivery system has to adopt the time. This is a matter of 2004. We moved a motion in 2004. The matter was heard. Matter was kept reserved. Then on one fine morning, it is released. And look at and at the end of the day, Lordships will take a call whether I have committed any misconduct. If I have committed a misconduct, then a DP can go on. My lord, these are all balancing of equities, my lord. When Honorable Court said you reinstate him, then my lord, what is the that order and today where? Why they have issued, subsequent to that they have issued 2 more show cause notices. They have appointed 3 inquiry officers. Why? So at the end of the day, the judiciary has to take a call depending upon the fact situation when the eventual decision is taken. Now, therefore, my humble submission is, yes, there are 2 earlier orders. I am not disputing that these are all annexed. I am saying that let them proceed with, but they will not pass any final order. And let them file their affidavit within 2 weeks. Also fix the matter after 2 weeks.
No,
That's what.
if we direct the UGC to conduct an inquiry,
Yes.
then whether the UGC will be able to complete the inquiry within 2 weeks?
Yes.
4 weeks, my lord.
Now, my lord, of course, my learned friend is at liberty to make any submission, but I do not know how come he is making that submission. Lordship will direct UGC to make an inquiry. Your duty is to file an affidavit. In the affidavit, you point out whatever you like. Why you are calling for an inquiry from the Honorable Court?
There are instances, my lord.
No.
This has been done by this
No, you'll get your turn. You can also say that, no, we are going to conduct an inquiry. We will file the affidavit after some time. But it is university's wisdom. That's why I say there is no bar in making that prayer. Is it really necessary?
Necessary, my lord. To find out the fact is necessary.
And Assam government has conducted an inquiry. Assam government found 3 universities. Anyway, I leave it to Lordships, my lord. I am not saying it. Only thing is, prima facie, it's not a misconduct. Therefore, I am saying, my lord, because of the intervening delay, I am entitled to some protection. Because the situation warrants. If the matter would have been decided when the matter was on, my lord, 19/11/24, the matter was reserved for orders. So if the order would have been passed by 1st week of December, things would have been different. Now, because of the change in circumstance, my lord, and my learned friend says, what would be the prejudice? I'm sorry to say, my lord, does he know the meaning of prejudice? If a disciplinary proceeding is initiated against a person without any misconduct, and he questions what would be the prejudice, my duty is only to take part in a proceeding. I have not killed them and I'll face a trial. And the PP will say there is no prejudice. I'm very sorry to say that, my lord. You should be very sensitive about people's right. You know you are appearing for government, but you should also be respectful towards the rights of every party.
As my learned senior sir has pointed out, that
if he be, allowed to be proceed,
Hmm.
and we will not, take a call with that.
Very well.
That will not take many days. That will not solve the.
Yes, yes.
Third is again, learned Chino Council assisted by Mr. Our Islam learned council for the petitioner. Mr. Kesomoa learned something council for the UGC, as does learned.
I'll be appearing for 1, 2, and 3, my lord.
I'm 4 minutes.
At number 4, Mr. S does learned. Something council for the lesson number 123.
1, 2, and 3, my lord.
123.
I'm 4. 5 to raise the.
Yes. This petition under Article 226 of the Constitution of India, the petition balance the departmental proceeding initiated against same person to the so-called notice dated P6/2017 number bearing number PC stroke MISC stroke sorry. There's 54 stroke 2006 stroke 209 and the next are 19. And the consequential order dated 19 and next put in bracket, next are 25. And also Primo issuing direction to the respondent number 2 cancel for VA. The impugn departmental proceeding initiated person to the super notice dated 6/2017. And the consequential order dated 19/10/2021. Where's the petition and the documents plus record. And also parallels annexure 19 and annexure 35. Let notice be issued to the respondents returnable 4 weeks. Although no formal notice is required to be issued since all the respondents are represented by their presenting counsel. But the extra requisite copy of the petition be. But no, respondent number 5 is there. Notice has to go. Mr. Sodore.
I raise the.
Well, by register post.
Stick upon respondent number 5 be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks and pending further consideration. The impugn departmental proceeding initiated person to the so-called dated 3/6/2017 shall not be given to final consideration. List after 4 weeks.
Deep level.
Shall I have to go for it? UGC has to go for an inquiry.
No. If necessary, we will consider it.
Kindly clarify that it will proceed, but shall not be.
Yes, final consideration.
No, final.
Shall not be given.
Timing item
Also.
5 for motion.
Though I have not received the written instruction, but I have been told that today it is fixed for loss of some verification of the person whose result has been withheld.
Whose?
Result has been withheld.
Hmm.
The verification is going on for the person whose result has been withheld. They are requested to submit their document if they can. So Lordship may can take it up next week, any day, Lordship, Monday or Tuesday. Let the verification finish, Lordship.
Okay.
Verification, my lord, already once done, my lord.
No,
and
today is for the withheld. His result has been withheld. Like that, there are so many other candidates whose result has been withheld. So they are, if they can produce their required documents, so for that verification is going on, Lordship.
Okay. Heard Mr. Professor learned counsel for the petitioner and Mr. For the second period, which is my part. Student number 1, 2, and 4. Next assist submits that. Verification in respect of the candidates whose results have been withdrawn. No, withheld is going on. Then the press will listen the matter after a week. They are allowed to listen the matter on Monday.
Monday, my lord.
On 10th November. Timing item 6 for motion.
May it please your lordship. My lord,
This matter relating to Millard's petitioner is a assistant professor of English department in Nagaon Girls College, Millard. Millard, she took earlier child care leave, CCL, Millard, in the month of January 21, 2025
Oh,
to
oh, how many
24
days?
for about 35 days
45
in January. Now she
as per-
applied
As per rule, you are entitled to how many days?
720 days total up to the age of 18 years of my children, Millard.
Hmm.
I have annexed the rule also, Millard.
Hmm.
Now this time I have applied for the period 3/3/25 to 11/4/25 at about 41 days, Millard.
Hmm.
Now, Lordship, the application is at page 31, Millard. Lordship, may kindly pay page 31. This is the form, Millard, where the petitioner, before leaving for Kolkata for the treatment of the child, has filled up this form at page 31, Annexure 6, where the name of the applicant, designation, everything has been given. The name of the children is also given. Two children are dear, Millard. One is born in 2013 and second one is in 2015. Both are minor, Millard, till today. Now, Lordship, may kindly, the period at serial number 9 from 3/3/2025 to 10/4/2025. And the address given Rabindranath Tagore Hospital, Kolkata, Millard. Now, this was submitted on 1/3/2025, Millard. Now, Lordship, may kindly turn to the rule at page 39, Millard. Page 39. This is a latest rule, Millard. It was issued by the governor on 7 April 2025. And it was earlier in supersession of the earlier rule dated 16 September
And that's already the
2015.
rule provides that you are entitled to 7.
Yes,
days?
Millard.
Which proof?
Millard, same rule. Earlier rule also written, same the conditions are there, Millard.
Rule 3.
Rule 3, Millard. Yes. Rule 3, child care leave for minor children.
70 days.
A female government employee or a single male government employee who has minor children up to 18 years of age and has custody of the children may be granted child care leave, CCL, by a competent authority on an application in Form 1 for a period of 2 years, 730 days during their entire service life for taking care of up to 2 minor children, whether for rearing or to look after any of their needs like examination, sickness, etc., subject to the following conditions. These conditions, my lord, next your lordship, 3.3. The child care leave CCL may be availed in more than one spell up to a maximum period of 3 spells in a calendar year. I have availed only one. Now, lordship, may kindly take next page, Miller 440, Rule 6. A separate leave account shall be maintained for child care leave CCL by the competent authority similar to that of earned leave or half pay leave, etc. Miller. Next 6.
Okay.
7, Miller.
Okay.
No, what happened, Miller? Lordship, may kindly page 37. What happened, Miller? This is the application when this petitioner joined. She has submitted this application on, Miller, 12 April 2025. This is joining. I have
Yeah,
formally.
okay.
Miller,
Yeah,
this is.
no, Mr. Tobler,
Lords-
why it was converted to early?
Earned leave. That I have to take instruction and file application for police instruction is also be required. Because police is the authority who has granted the leave and lordship the instruction from them also it is required. Mainly the principal mainly. Yes, principal is the mainly actually. Principal and the governing body also.
Okay. Heard, Mr. Argusami learned it for the Mr. Hobilder learned something from the respondent in higher department.
For 1 and 2.
For respondent number 1 and 2. Then where is the impugned letter?
My lord,
Where is the impugned letter?
impugned letter is
Earned leave, no, child care leave was converted to earned leave.
yes, page 37. Only simply EL mark is there, my lord, under, this is, my lord, circled. Child care leave from 3/3/2025 to 11/4/2000, at the top EL. And it was forwarded to keep on record, my lord. This is the impugned letter, my lord. In my application, we have simply marked this period as EL. So, my lord, this may kindly be stayed. Because he is entitled, my lord, 720 days. This is a period of only 40 days. And my lord, I have annexed all the documents during that period, my lord,
Mr. Goswami,
lordship.
this letter is written by you to the principal.
Yes.
This is not the letter of the principal.
No, not letter. Some simply marked this as EL, my lord. And in, my lord, this is a matter of college authority only. No,
Let him obtain instruction. We will see later.
till then, my lord, this, my lord, may kindly be stayed, because, my lord, if
No,
it is converted to EL.
Mr. Goswami, perusing this page number 37,
Yes.
it cannot be said that this EL was marked by the principal of the college.
No, this, what happened, my lord, I have somehow got this, my lord, photocopy of this letter.
Okay, we'll see finally.
My lord, then, my lord, subject to the result of this much, my lord.
Let notice go at this instance. Art Mr. Goswami, learn it from the Builder, learn it, nothing also for the respondent number 1 and 2. 1 and 2. This petition of Article 326 of the Constitution of petitioner has right for passing and setting aside the illegal action of the respondent number 3, by which the respondent number 3 has converted the child care leave of the petitioner to earned leave on the body of the application submitted by the petitioner. Petition. Mr. Goswami, learned counsel for the petitioner, submits that the petitioner is serving as, in which department you were serving?
English department, my lord.
Serving in Nagaon Guards College in this department as assistant professor. Then on account of the illness of her son, she has applied for granting her child care leave with effect from 3/3/2025 to 11/4/2025. And after filing the application, she joined again on 12/4/2025. 2025, but later on she came to know that the child care leave, which she has applied for, is converted to earned leave without any reason by the respondent number 3. That being active, the petitioner approached this court. So Bhuyan, learned standing counsel for the respondent number 1 and 2, submits that he may be granted some time to obtain extension. The submission of learned counsel for both the parties needs further consideration, and this is that notice be issued to the respondents, returnable in 4 weeks. Step upon respondent number 3 and 4 be taken by registered post with AD and also by usual process. However, no formal notice is required to be issued to the respondent number 1 and sir. Builder and third appearance and receive notice. However, extra requisite copy of the petition will be furnished during the course of the day. List the matter after 4 weeks. In the meantime, Mr. Bhuyan shall obtain necessary inspection and place the same before this court on next second. List the matter of after 4 weeks.
And in the meantime, the conversion of from CCL to EL, subject to the, at least this much, subject to the result of this case, my lord. Because, my lord,
Except your contention, there is nothing in black and white.
yes, my lord, but what this petitioner can do, my lord? Because the principal, what happens, my lord? given to the, my lord, clerk. Then the clerk, my lord, it makes from CCL to EL. Then this will carry after, my lord, then the service rule, everything will change, my lord. This is the fact, my lord.
So, Mr. Kusami, learned counsel for the petitioner, referring to the rule. Referring to the notification dated 7th of April 2025, especially Rule 3, submits that the petitioner is entitled to 730 days of CCL, but she has availed only on one occasion. For how many days?
35 days.
35 days.
From 20/01/2025 to 24/2/2025. But the rule says that it can be availed 3 times in a year.
In a particular year or?
In a particular
throughout
year,
her
my lord.
service period?
3, my lord. The child care leave may be availed in more than one spell up to maximum 3 spells in a calendar year.
More than 3 occasion in a particular year. Then she had availed only on one occasion. And as such, the conversion of the child care leave to earn leave is illegal and arbitrary, and the same is required to be interfered with. Though not granting any interim relief at this stage, it is provided that the conversion of CCL to the earned leave by the respondent number 3 is subject to the outcome of this litigation. List accordingly.
List on 28 November.
Obliged, my lord.
Item 7 for motion.
In this case, as per my instruction, midday meal is going on under the supervision of BEO,
Under the
BEO, block elementary
block
education.
elementary.
So I have also taken instruction. My instruction is that the midday meal is running from the quota of the old stock of rice. But it is going to exhaust lordship shortly, lordship. But the school authority, lordship, not allowed me to leave the fresh quota of rice, lordship. So that is my lordship apprehension, lordship, because once it is exhausted, there are more than 500 of students, lordship. Now
Mr. Dekka, you say in the morning you have
So we are
submitted one
facing-
thing and now you are submitting another thing.
No, because I am submitting, we are facing difficulties because I am not allowed to, run the
So
midday
if
meal.
it is provided by the block elementary.
No,
education officer,
actually, we have to leave the rice from the society, lordship, from our society, lordship.
let the
from
block
the
elementary
allotted-
education officer to lift it from the concerned office.
So kindly see the lordship, the law, lordship. The law, lordship, apparently, lordship, by violating the lordship, existing law, lordship, the GI has issued this order. There is no doubt about that regarding the date of joining. So if you counting the date of joining, the
No, that's
petitioner,
what, let her file affidavit.
but lordship, but till then, lordship shall not be given effect. Or otherwise, lordship, since lordship, my learned friend is lordship submitting that
No,
BO has
even
done it.
if one
That's-
status quo order is operating.
Yes, because of the status quo order, lordship, I am still holding the chart. So I may be allowed to leave the fresh quota of rice, lordship. That is my prayer, lordship.
No, if the block elementary education officer is taking.
It's
the
a time being,
decision,
lordship,
then
it is a time being arrangement, lordship.
No. Let her file affidavit, thereafter we will consider your prayer. Heart Mr. Dekka, learned counsel for the. Miss Sophia, learned standing counsel for the respondent in the elementary education department. Sophia submits that, she may be granted some time to file the affidavit in opposition. Where is allowed? Yes, is the matter on. Public.
19 words.
So lordship, an endeavor with
17.
But whether notice was issued here.
Notice perhaps.
notice is yet to be issued, lord. Notice not, that is why, lordship, last occasion, after hearing the lordship, all the parties, the government was direct to obtain instruction as to why he was not allowed to hold the charge.
It appears that notice has not yet been issued to the respondents. Accordingly, it is provided that notice be issued to the respondents, return accordingly. Okay, when?
On 17 November.
17 November.
So 1 to 4 I am available. 1 to 4 I am available. That's one number.
One performance notice is required to be issued to respondent number 1, 2, 3, and 4. As is Sophia. Entered appearance and receive notice of our extra requisite copy of the petition to be furnished to her during the books of the depot. State of respondent number 5 and 6 taken by the reference to ATN also questioning process will be working days from today. Additionally, the sea service is also permitted. After effecting service of respondent number 5 and 6, the learning. The traffic experts will find that affidavit. To that effect. Place the matter on 17.
So in view of the interim, also, I may be allowed to leave the fresh quota of rice lots. Because still I am holding the charge. Interim is still operating.
Is already operating.
That is why, so my respectful submission is that still, let's say, I am holding the charge.
The block elementary education officer will do the need.
Let's say it is a stopgap arrangement, let's say.
Maybe.
Timing,
Then interim that will continue. No,
Interim will
interim order earlier past then continue.
Okay.
timing item 43 for motion.
Apply lot.
We'll have to resume at 2 months.
It is already 1
No,
o'clock.
for another 15 minutes, we will continue.
Yes.
Not our
Yes.
The question that is involved ultimately in this petition is whether the cutoff mark in an interview, once notified and accordingly cleared, candidates were clear, can subsequently be increased and then say, no, you are disqualified. This is the crux of the issue here. Kindly see what happened here, facts.
No, you show me the document by which the cutoff mark has been fixed.
Yes, page 43. Page 43 and Nexus 7. This is Office of the Director of Secondary Education, Kailipara, revised cutoff marks of TCR 2024 paper 2.
Paper 2 is postgraduate teacher.
That is for the postgraduate teacher. This is for candidates who are presently called for document verification. Now, kindly come to column 3, left hand serial 3. Advanced Bengali and Bengali, we are concerned in this subject. 4 petitioners are before your lordship. And our medium is Assamese and English. And lordship will see Assamese, that Assamese medium schools, cutoff was declared as 41.75 and English medium 53.75. Now, kindly see page 64. After this, we were called for verification and we were cleared. We were cleared, annexure 9, lordship will find. I am showing one at least, the result. Petition number 1. Acknowledgement form of document verification for recruitment for the post of graduate teacher under Government of Assam. This is full name so and so. Applicant date of birth so and so. Verification status accepted for further processing. This is eligible medium of school preference English and English medium school. This is. So also the other 3 candidates. Now, kindly come to page 59. It is a notice given on 17/10/2025. They say the results will be published for TCR at the official website of the Director of Secondary Education Assam, that is so and so. Candidates will have to log in by entering their application number so and so, password used while filling up the forms of the time for applying for the post.
When you log in.
The results of the candidates declared to be successful are provisional and subject to fulfillment of eligibility criteria is prescribed in the advertisement and veracity of the documents and declaration made by the candidates. Technical support so and so. This was the notice issued on 15/10/2025. And then
This is the result. We log in.
once we log in, we find that
our
not
result
qualified. Page
11, 60,
60, my lord,
and actually 11,
Annex 11,
middle part.
middle part, Lordship will see result, not qualified. Lordship got it?
No reason whatsoever is visible.
No reason has been shown. They said not qualified.
Yeah, subsequently.
So, not qualified. All four are not qualified. Second page also. Third page. Fourth page, not qualified. Then kindly come to page 64. They have issued this final cutoff marks of this year 2024 for the post of graduate teachers.
So we compare with the other.
Now kindly see the other one, first one I placed before Lordship, page 43. And this page 64. Annex 12. Here they say advanced Bengali, Assamese, they have increased it to 52. Initially it was 41.75 and English 58.25. It was earlier 53.75. Now this has gone up to 58.25. And this was the cutoff mark. They have final, they call it final cutoff marks. And the earlier one, they call it revised cutoff mark. So revised cutoff mark itself shows that they have initially looked into, found it, decided something, that subsequently they revised it, and then they published it.
And we also very.
Revised itself is the final, it should be treated. And how come the second final cutoff mark comes? And that again increases. Kindly consider, the cutoff mark is always taken up to decide the eligibility of the candidates above certain level. So they do it and they say that we have revised it once and they have declared it. And then can it be, is there a chance to enhance it again? How was not it was done earlier?
And it happened for only this subject. Only this.
I am only for these two subjects they have done it. I am only for advanced
Bengali. And
Bengali,
Bengali.
Assamese and English medium schools. And now we are ousted. How is this? We fail to understand. What is the logic behind? Had it been decreased that yes, they have decreased it because first batch gone with higher cutoff. That still remains post vacant. Therefore, they can reduce to include some more candidates. It can be reduced. And then the second cutoff mark for the rest of the candidates is this. It is, yes, plausible and it is understood. But how come once you declare that this is the cutoff, below that nobody. And you accordingly clear them, take everything. They say, yes, accepted, gone, verification done, cleared.
No, if the candidate secured higher marks, then whether the authority is not entitled to
Well,
upgrade it.
Well, if the candidate had secured higher marks, they would have found out at the first instance itself when they revised it. That is what I am saying. They have taken the call by going to the highest mark secured, then coming down, then what should be the cutoff mark? Best cutoff, including the taking into consideration the number of vacancies, candidates, and then what should be the cutoff to accommodate those persons. It may be
Only person that
They-
will be called for verification list. And we.
because it is 1:1.
Honest.
They have chosen the candidates 1:1.
And we are called.
Not that they're 1:3, 1:2.
Hmm.
Therefore, my full submission,
Personal merit will be called, and that is why we have called for verification. Only we should have and above the merit.
here,
And actually,
either they have not done it properly, there is something wrong, serious wrong in the process, or they didn't apply their mind, or there is something fishy here. Therefore, my full submission is Let them come up with all details. And meanwhile, Lordship will say at least 4 posts in this particular subject may be kept vacant.
Because they're soon going to fill up the post.
Because they are going to make appointments here. Apparently, there is arbitrariness, something wrong is there. It cannot happen.
Whether in the advertisement, they have fixed any cutoff mark.
No, they have not said about any cutoff, but what they said, that the marks secured in the TAPCAM recruitment test is the mark. It is not a very big mathematics. They say that the marks that is secured in the TAPCAM recruitment test, that is the final mark.
Page 40,
Page 40, Lordship will say,
preparation of merit.
preparation of merit list. My lord, this is 13, serial 13, Roman. Preparation of merit list. Merit list of candidates for graduate teacher, postgraduate teacher shall be based on the total of marks obtained in the TAPCAM recruitment test. And as per selection criteria mentioned in the earlier advertisement.
Yes, Mr. Mozumdar?
Yes. I'll elaborate after 116 AC Lordship is rising at once, but basically, the whole writ petition has been prepared on the premise that there is a cutoff mark and subsequently we have changed. And in the entire selection process, I'll show from the advertisement and the subsequent addendum. There is no concept of cutoff mark. Advertisement says,
Yeah, that's all right, but why you have issued this Annexer 12, Annexer
no, I'm coming to that. Well, I'm coming to
retreat,
I'm coming,
of mark?
no, Malad, I'm coming to that, Lordship, kindly bear with me. What happens, as per the advertisement, Lordship, kindly straightway turn to page 23, man. Start page 22, the advertisement starts. Page 23, Lordship has got.
Yes.
So it's a advertisement for filling up 102 vacancies of postgraduate teachers in different government secondary schools. Now your Lordship comes to page 23. Lordship will find page 24. Now first I show page 23, the criteria for selection.
Yes, yes.
Serial number, my lord, you also will find there is one serial number physical fitness. Then number 2, criteria for selection of postgraduate teacher. Teachers eligibility test cum recruitment test. 140 marks in the following paper. First paper shall be 140 marks pedagogy, 50 marks about Assam and its paper, etc. Marks are given. Then Lordship will kindly see page 24. Page 24, whether small e. The number of qualified candidates in the TET cum recruitment test shall be in the ratio of 1:1 of the vacancies advertised. Then F says, in case any post remains vacant after publication of the first merit list as per the ratio of 1:1, then maximum 2 more numbers of merit list will be published. Then Lordship will kindly see in the addendum, which your Lordship will find at the page. It starts from 34. I am referring to page 40. There is 38, another addendum, start from 38, page 40 is the relevant part. Lordship is got page 40.
Yes.
This is Roman 12, man. For verification of qualification and other particulars of the candidates, a draft merit list will be prepared with a ratio of 2 candidates against 1 vacancy. Initially, it was 1:1. One post, one for a candidate against 1 vacancy, which I read just now. Now it says in the addendum that for verification of qualification and other particulars of the candidates, a draft merit list will be published with a ratio of 2 candidates against 1 vacancy. Then second sentence, madam.
Thereafter, after verification, a final merit list will be prepared from the draft merit list as per the outcome of the verification report and as per the merit in the draft merit list in the ratio of 1:1. Finally, it will be 1:1 because against one vacancy, one person will have to be appointed. But before that, considering the fact that if there are more vacancies after preparing a list on the basis of 1:1, some more vacancies are left out, then we can prepare 1, 2 more vacancies. That means we can prepare altogether 3 if, depending on the number of vacancies. Now, what is cutoff mark? Now, if we have to prepare, suppose I'm giving an example. Supposing there are 10 vacancies, and after selection, since we have to prepare the list as per the ratio of 1:1, 10 persons will have to come in the list because there are 10 vacancies, and we have to prepare the list in the ratio of 1:1. So, in the list of 10 persons, now we prepare on the basis of a ratio of 1:1. The percentage of marks obtained by the last candidate becomes the cutoff mark. It's not that we already have a cutoff mark and based on that we prepare the select list. No. We are.
That's all right, but why you have issued this page number, this annexer 12, annexer 7?
My lord, that is what I'm saying, when I'm explaining. Now, in this case, in a present case, what has happened, my lord, after we prepared initially the list, we found that some more candidates were left out, number one, because of the diploma they had and they were otherwise eligible to be incorporated in the first list, number one. And number two, after preparing the list in the ratio of 1:1, there were more vacancies, so we had to prepare another list. Now, initial was a draft one, that is why we say the draft list. Now, when we prepared in the draft list, the cutoff mark, because of the number of vacancies and the number of candidates we have, based on which we have prepared the list, it was 1:1. The lowest person who got selected, the last person who got selected, his percentage of marks was the cutoff mark. Now, moment we prepare a list with 2 persons against 1 vacancy, the number of selected persons will be more, and the cutoff mark will naturally be more now, my lord. Am I clear, my lord?
No.
Against 10 vacancies, my lordship, kindly, just one example. Against 10 vacancies, if we prepare a list of 10 persons, the percentage of marks obtained by the last person will be a particular percentage. Now, against these 10 vacancies, if we have to prepare a list of 20 persons, now 20 persons are coming within the zone of consideration. Now, there, the percentage of marks obtained by the 20th person, last person, becomes the cutoff mark. It is not that we are preparing the list on the basis of a particular cutoff mark already decided. We are preparing a list. Then the percentage of marks obtained by the last person becomes the cutoff mark. That is how I use the cutoff mark.
That's all right.
My lord.
That's all right.
Yes.
The problem is this annexer 7 and annexer 12.
Annexure 7. Page 40. Page 40.
Under what circumstances you have issued this this notice?
My lord, that is why I am showing
Revising the-
why we had to prepare another list, my lord. Your lordship is referring to the final list, my lord. And first, your lordship will kindly see page 42, my lord. Page 42. You can keep it. All right. My lord, kindly see page 42.
Yes.
It is a notice for a final publication. For the draft. It is hereby informed to all concerned that TETCOM recruitment examination 2024 held on so and so, that the marks obtained in the written examination as well as weightage marks for the post of postgraduate teachers paper 2 will be available for downloading from 11 AM on 30th of May 2025 at the official website of the Director of Secondary Education, Assam. Candidates will have to log in by entering their application number and a password used while filling up the forms when applying for the post. Candidates who are presently selected for document verification can download their admit card along with the tentative marks
Such candidates will have to appear at the designated venue on specified date and time along with required document as mentioned in the admit card. The selection of the candidates is subject to the fulfillment of the eligibility criteria as prescribed in the advertisement and veracity of the documents and declaration made by the candidate. Technical support toll free number so and so. For the post of graduate teachers, paper 1 notice shall be issued shortly. The director of secondary education Assam will not be responsible for any typing mistake. My lord, after this, on 3/6, there was a corrigendum. So that corrigendum is not, I have handed over a copy, my lord. It was published in the website, not a document lying in the office. It was published in the website.
Mr. Mazumdar will resume at 2 o'clock.
My lord, my lord.
I had filed CRP, my lord, and that lordship may have a look. And the view of this honorable court. In the same, that's how this second appeal came to be filed.
But the statute does not provide for second appeal.
I did file a CRP, my lord. That was converted into a, that CRP came to be converted into a second appeal. That is how the second appeal came to be filed. মানে protect কৰিলে যে তুমি এইটো নহব, it has to মানে মই যেতিয়া দেখুৱালো গোটেই CRP, মই initially CRP file কৰিলো. Honorable Justice Surana said that it should be a second appeal. Huh? Yeah, that came to be converted into a second appeal. That is the position as it stands, my lord.
But I will go by the statute.
Yes, CRP is one because after the 1972 Act was passed, after areas were recovered. Then, my lord, there is a confusion, lot of confusion. Many of the lawyers used to file one appeal, one second appeal, and one revision. Ultimately, in 1978 came the decision of the full court of this High Court. And there it was decided that appeal would not lie. There will be civil division.
Perhaps that decision was not placed before the court, therefore this observation was made.
So revision line.
So,
that
madam, you see, I can dismiss the petition being not maintainable,
My
but
lord.
I have not done it. Simply because you may withdraw it and you may avail the appropriate remedy provided under the statute.
File a CRP afresh.
Yes.
CRP, my lord, already exists. I'll give the number, my lord. Lordship then decides the CRP, which came to be converted.
No, you have withdrawn the CRP.
In pursuance of this honorable court order.
Maybe, whatever may be.
Then lordship grants me that I don't lose in the limitation. That I don't lose.
Section 14?
Section 40 will protect the one.
Very well.
Section 14.
Very well.
So we'll list the matter day after tomorrow.
My lord.
Oh, no, sorry, Thursday.
My lord.
Oh, judgment in the other revision. No, sorry, other appeal, RSA.
Both the matters?
No, only that matter. This matter, okay, on that day we'll pass the order then.
Both the matters. my lord.
Yes.
Yes, lordship.
No, you want to withdraw this petition or what to do?
I shall lordship records this, that it is only a CRP which is maintainable, and I'll file a CRP afresh.
With the liberty, my lord.
Yes,
Okay.
That's civil protected.
Third, Ms. Justice Sharma, learned counsel for the appellant. Third, Arpit, senior advocate, assisted by Mr. N. N. Paite. Learned Council for the response. List the method on Thursday for judgment.
Obliged. Number 43 to continue. I was reading before the lunch session, my lord, page 41. Page 41 is a notice. Page, I'm sorry, page 42. Page 42 is a notice of 27 May for declaration of result. And my lord, page 43, lots will find there was a mistake on the part of the my lord, persons involved in the process in indicating that revised cutoff marks. Not a question of revised cutoff marks. And we have prepared a list on the basis of marks obtained by them of in the ratio of the 1:1. If there are 10 vacancies, then there are 10 persons. Now, on the basis of that preparation, the percentage of marks obtained by the last person has been indicated to be the cutoff marks. It is not that we have already determined the cutoff marks, my lord, at random, and then we find out how many persons come within that cutoff marks. Not that. Reverse is the case. We have prepared list in terms of the advertisement in the ratio of 1:1. Candidates, and Lordship will kindly see the language mentioned in page 43, my lord. Revised cutoff marks of ECR 2024 for the post of postgraduate teachers for candidates who are presently called for document verification. They have been called for document verification. And we found, my lord, that there was some mistake in not incorporating names of some of the persons. And subsequent addendum of 16/10/2024, which I have shown, my lord, which says that you have to prepare the list in the ratio of 1:2. That's after doing that exercise, my lord, the final list will be prepared.
That's all right, but once the game is started, you cannot change the rule.
That is why possibly I have not been able to convey. There is no question of changing the game, my lord. I'm again, my lord, repeating.
Then why you have notified? Why you have notified this Annexure 7?
Annexure 7.
43.
Page 43, my lord, we have notified. Also, kindly see one thing. After this note 27, this notice was issued. We have prepared a list on the basis of 1:1. This preparation of revised list of PGT on the basis of 1:1. That is the thing, my lord. We'll file an affidavit and clarify, my lord. 1:1. That and by preparing a list in the ratio of 1:1, there is 1 person against 1 vacancy. The percentage of marks obtained by the last person has been indicated to be the cutoff mark. Otherwise, this list has not been prepared on the basis of already determined cutoff mark. Kindly visualize this. So there is no question of subsequently changing the cutoff marks and preparing another list. No. And that is why, my lord, Lordship will kindly see on 3rd of June 2025, I have handed over a copy, which says where we have mentioned that there was some error for which we have to prepare the final list in the ratio of 1:2. Lordship will kindly see this. Office of the Director of Secretary Education, Assam, Kailipara, Guwahati, 19. Origin for cutoff marks of PCS so 44 of teachers for candidates who are presently called for document verification for the subject, advanced SMS in the Hindi medium and history in Bengali medium. Due to clerical error, cutoff marks of the following subjects for the course of PGT are to be read as follows. Those will kindly see subject name, second column, column. Advanced SMS, medium is Hindi. So for the Hindi medium and for the subject of SMS in Hindi medium, these are the marks we have mentioned. Similarly, for the subject of history in Bengali medium, we have indicated the marks. Then the last sentence also important. In addition to the above, due to inadvertent error while selecting medium of schools in the declaration of cutoff marks in certain subjects, more candidates are invited for document verification. So when more candidates come for document verification, it's not that we are bringing some persons who are not selected, not like that. It is because of the some mistakes, some persons who are eligible, their names were not there. Then initially the list was prepared on the basis of the 1:1 ratio. But subsequently considering the addendum which was already issued on 16/10/2024, where we were that is before the last year of submission error, which says the final list should be prepared in the ratio of 1:2.
No, that's all right, but can you do this? Because in advertisement,
My lord.
you have clearly indicated that it should be 1:1.
Yes, but addendum of 16/10/24 before the selection process, my lord, not before the last date of submission of application. 16/10, my lord, will you kindly see?
No, when the process is started after publication of the advertisement,
No,
when?
process started on 21/10/2024. Application accepted online up to 21/10/2024. Page 34. Look. But in the advertisement, you will not find any date or last date for the submission of application. Page 34, addendum, what you will find.
No. This advertisement was issued on 26/12/2023.
Yes.
So is it
without-
not the
without indicating-
date of initiation of the selection process?
No, my lord. Last date for submission of online application is the date from when the process starts. Before that, we can do anything. And that last date is 21/10/24. And we have brought this addendum on 16/10/24, before the last date. This selection-
Last date is indicated in which document?
Page 34, my lord.
34.
Page 35, what you'll find. Page 34 is the addendum, page 35, what you'll find how to apply Roman 1, then Roman 2. The online application will be accepted from 21st October 2024 to 15th November 2024. And that was extended to 20, my lord. 20th November. And we have brought this addendum on 16/10/2024. That is before that time. And here we have seen that
1:2.
page 40, my lord. There are two because two different types of features. Page 40, Lord, we will find Roman 12. For verification of qualifications and other particular candidates, a draft merit list will be published with a ratio of 2 candidates against each vacancy. But when we prepared the list initially, my lord, it was in the ratio of 1:1. And addendum says it has to be prepared in the ratio of 1:2. And after verification, my lord, some candidates may not, my lord, have any valid document, etc., etc. For this second sentence, thereafter, after verification, a final merit list will be prepared from the draft merit list as per the outcome of the verification report and as per the merit in the draft merit list in the ratio of 1:1. Because from there, the appointment will have to be made, and that has to be in the ratio of 1:1. So this is already there before the process started. It's not a case, but they are trying to project a case that after the game has started, you have changed the rules of the game. No. They are only saying that the cutoff marks you have subsequently changed. There is no question of cutoff marks at all. In the advertisement, lots will not find anywhere that this is the cutoff marks based on which you will be selected. It's a mistake on the part of our the authority which did it, because we have not done it. The selection process was undertaken by another authority, SEBA. Examinations conducted by SEBA. We have done. I'm just trying to justify what they have done. They have got a standing council also, your lordship. They should not, may have made them a party. They have not made him party also. So they have done it. So in the first list which was prepared, it was prepared by mistake in the ratio of 1:1, which was there in the initial advertisement. But subsequent corrigendum, which came before the selection process started, that said then it has to be prepared in the ratio of 1:2. Not only that, my lord, there was some mistake in the preparation which we have said by a corrigendum. For all this, we have prepared subsequently a final list. And in the final list, the cutoff marks which is becoming less than the earlier one is not because we have done something. It is because when the area gets bigger, my lord, and more persons come in the zone of consideration, naturally the cutoff marks will be more. And that is how it has gone up. We have not done anything, my lord. Once we prepare a cutoff mark, once we prepare a list in the ratio of 1:1, number will be less, just as much as there are vacancies. When it is 1:2, my lord, the number of candidates will be double the number of vacancies. There, when more people come in, the cutoff marks will naturally, my lord, go high. And this is how it has gone. And now they are trying to project. Let's see, initially you have fixed the cutoff marks, and based on that, you have prepared a select list. Now you have changed the cutoff marks and you have prepared a separate cutoff list. This is not the case, ma'am. And it has been done.
Practically, that is the situation, but in documents, these documents, this annexer 7 and annexer 12 speaks other way.
No, my lord.
In annexer 7, there is a revised cutoff mark, and in annexer 12,
that's what
there
I'm
is a
saying.
final cutoff mark.
My lord, that's what I'm saying. The advertisement, the addendum, nowhere mentions the selection will be on the basis of any cutoff marks. It is a mistake on the part of the authority who did it in mentioning the cutoff mark. They can, they get a cutoff mark from the list prepared. Once the list is prepared, the percentage of marks obtained by the last person in the list becomes the cutoff mark incidentally. We do not fix. The authority doesn't fix it. It is taken from the percentage of marks obtained by the last person while preparing a list in the ratio of 1:1.
Okay. Yes, any reply?
Yes, my lord. My lord, first thing, the corrigendum which has been referred to by learned friend, the learned additional advocate general, doesn't apply to our subjects. It is Assamese and history. They have clarified in respect of these two subjects. Lordship, can you see once more? This corrigendum doesn't say that some mistake in the other subjects or in particularly in Bengali and all. It says only Assamese and history. Advanced Assamese and history.
Bottom paragraph.
And bottom paragraph, what it says? Bottom paragraph, in addition to above,
Due to inadvertent error while selecting medium of schools in the declaration of cutoff marks in certain subjects.
in certain
Which
subjects.
includes their role.
Yes,
More candidates are invited for document verification.
that can be. Now let me explain, my lord, what explanation my learned friend has given. That is just opposite is the practice. Kindly see. Let us take it. Presume that 10 posts are to be filled up. And there are 50 candidates applying. And then they have written the test and marks should be the final deciding factor. Now, out of those 50 candidates, who are those 10 candidates, if you take it 1:1, to be listed, shortlisted against this 10 post? From the top, somebody has secured 70 marks. This is the top mark, 70 marks, the highest mark. Then come down to the 10th position, it has secured, say, 60 marks. 60 remains as the cutoff. That is what they are saying. Now, they say that the zone is expanded subsequently because of the corrigendum, that now you go for 1:2. If you are to go for another 10%, then in that case, 10 has already been earmarked, 70 beginning, 60 ending. Then you are to expand for another 10, then you go down from 60. You go down from 60 and close at 50. That is the procedure. It is not
that because you will expand, the marks will go up. No, how can? Impractical. How can? That is why, my lord, first thing, you have revised it. That revised, maybe on the basis of that corrigendum. They have revised it, they have found it. And subsequently, that is why I argued initially, I argued that when they declare the final cutoff mark, that can go down, not increase. That final cutoff mark, if at all we call it, then it cannot go up than the marks which was already fixed. And out of that 20, you select. Obviously, if somebody, those 20 shortlisted, then if the 60 mark, the candidate who secured 60 mark, he doesn't come in for joining, then it will go to the next below person. It may be 59%. This is how it is done. This is how results are declared. And the question whether cutoff mark has any relevance here, there is no question at all. And you have to maintain transparency. Merit basis selection. You will have to maintain the transparency. Look, on merit, this is how the last mark we have found, and candidates above this only, they will be considered. That's we can very well understand. Subsequently, if you expand the zone, that mark will definitely come down. It will not go increasing. Cannot. Impractical thing. Simple mathematics, my lord. Therefore, my respectful submission, there is something mischief done. It would not have happened. This amounts to changing the game entirely. Unfair practice. Unfair practice. They have chosen, they have gone for, they have cleared us that yes, you are clear. Verification done, cleared, everything done, then they have raised it. How come that whether those candidates who secured higher marks were ignored earlier? Totally. And therefore, that mark didn't catch the eyes of these officers, and that was never taken into account. Can it so happen? If it has happened, it's a very serious thing done. Therefore, I say, my lord, there is something seriously wrong here. They could not have done it. What explanation my learned friend is trying to give is totally impracticable. If you have expanded the zone, that will include some more persons who have secured lesser mark than the mark you have already notified. Then only they will come in. Otherwise, persons securing a higher mark than the marks already notified, how can they could have been left out in the first round itself? Am I clear to your lordship? This is the position. And ultimately they fix on 1:1. That means 1:1. If they have taken into it 1:1, initially when they choose this cutoff, it is 1:1. Revised cutoff. If they say that it was because of the 1:1 first notification, then yes, then this is revised cutoff we have shown. These are the revised cutoff. That means this is the lowest mark we have fixed. Candidates securing marks above this only will be called for verification. That is the purport. And subsequently they say, no, because of the corrigendum, we missed it. We had to expand the zone. Very well, you can expand the zone. Then in that case, it will come down, not go up. Obviously not go up. It will come down. Then the last marks, which you have already notified. So how can it go on increasing? It is something unheard of. Something unheard of. Therefore, when the zone is expanded means you go, the list go down. From the top, it goes down. Because selection is always from the top. First selection is always from the top. First 10 persons, 10 post. You take it from the highest mark to the 10th position. Then stop. But when you say that no, we'll have to take another 10 persons in the fray, because somebody may come, somebody may not come to join, then in that case, you will go down after that mark only, not above. So, question of, well, rejecting our case doesn't arise at all. They cannot declare us subsequently. They subsequent after 3 days of, they say they have come up with this revised marks. I mean, the final so-called final cutoff mark. We have been, our case was rejected. They declared us unqualified. Na ki kole? Not qualified. Not qualified. They have shown us not qualified. And thereafter, they have issued this mark, final cutoff marks. It was thereafter found in the website. This is. Therefore, my lord, I see no reason for the final cutoff mark. Our marks, Lordship will see at Annexure 8, page 47. We were very much within the cutoff 54.25. Above the revised cutoff. And then 58, second candidate 58, her marks was at 58, then third was 48.75, all were above. And therefore, there were students, they were asked for to come for verification, and they were cleared. Accepted for further processing. That is the remarks given, page 56, 55, 54, all there. This is the remark given. These records will not tell the lie, and we can understand how the marks are fixed. How the marks are fixed. This shows the revised cutoff. The revised, very term revised itself indicate that they have applied mind twice, thrice, and then only revised. And that revised cutoff means the person below that, securing below that mark will not be asked to, will not be allowed to come for further process. This is the purport.
Mr. Mazumdar, you file your affidavit?
Will file.
But
Lordship will just see one more thing, page 43 and page 34. There is no change in the cutoff as far as this Bengali medium is concerned, with which they are concerned. Lordship will kindly see page
43.
No, we are not, we are Assamese English.
No, we are not on Bengali medium. We are teaching Bengali in Assamese and English medium school. That is what we are saying. This Assamese 41.75, English is 53.75. We are concerned with the medium, not the subject.
Oh, we will issue notice. In the meantime, we will keep 4 posts
Yes,
vacant.
deeply applied.
Please subscribe for weeks.
Otherwise, the process will continue.
Process will continue.
In rest, you can go ahead. We have nothing to say. Returnable, Lordship will make it returnable by 4x.
4 weeks.
Deeply applied.
Elementary education officer has wrote down, your lordship, a letter to the pension director, your lordship. I would like to place it. Regarding return back of service book of late Jitendra Kumar Das, expired picture of Ben.
Colton
Way School. Like to read it, your lordship. With reference to the subject cited above, I have the honor to inform you that as per written statement submitted by Srimati Beena Das, wife of late Jitendra Kumar Das, expired teacher of Ponton ME School under BEO, Soigaon. The service book of late Jitendra Kumar Das was submitted to your esteemed office in the year of 2012. The Honorable High Court has direction the undersigned to reconstruct the service.
Okay,
book
all right.
of
Mr.
deceased
Devi,
teacher.
this letter was addressed to the Director of Pension.
Bench.
You ensure early returning of the service book.
Already one letter, this letter has already furnished to the GSA. This letter for his convenience.
Whether you are a party, Mr. Devi here?
Yes, sir. Yes. He is appearing for the director pension. He is appearing for the director pension.
Okay. Heard Mr. Hope, learned counsel for the petition. Also heard Ms. P. Das, learned standing counsel for the respondent.
7 and 8, second verification.
7 and 8. Mr. Devi for respondent number. Respondent number 4. During the course of hearing, Ms. Das has produced a letter to the District Elementary Education Officer Kamrup Amingaon dated 29/10/2025, whereby the District Elementary Education Officer Kamrup has requested the Director of Pension, respondent number 4, for returning the service book of the petitioner to take action as per order of this court. And she further submits that a copy of the letter is handed over to Mr. Devi, learned standing counsel for the respondent number 4. In view of above, it is provided that recessal lays the matter after 4 weeks.
Obtain instruction for reconstruction the service. Okay.
My lord, actually, in this case, my lord, what happened, my lord, the petitioner earlier was sanctioned family pension, my lord, on the basis of service book, my lord. Now, my lord, probably, my lord, director pension has misplaced the service book, my lord.
It will to reconstruct the service.
No, if the service book is there with the Director of Pension, why a reconstruction
Yes,
is
my lord,
necessary?
that is the thing, my lord. Why they need reconstruction?
Yes, madam.
As your lordship, this one earlier, I have one subject. Later, your lordship, file was not found, service book was not found, your lordship. That's why your lordship, District of Elementary Education Officer has wrote down, your lordship, that the service of book is needed to be reconstructed.
No, if the Director of Pension is returning the service book, then
Now,
where is the
Lordship,
necessity?
Director of Pension will obtain instruction whether service book was available or not, your lordship. So on the next date, your lordship, Director of the Pension will give the direction to obtain instruction.
On one occasion, expected 72,024. Wherein, inspector of school, Mingaon was requested to submit a duplicate list of reconstructed service book. So,
No.
they communicated the same to the Director of Pension. So, let's it's a matter of next week. That I cannot say. Okay, recessal is the matter on Monday. So as to enable Mr. David to obtain up to date inspection.
On 12 Wednesday.
The letter produced before the court today shall be marked as an XRP and be tagged to the record.
I am okay.
Standing items 20 and 21 for admission.
Hearing the affidavit has not been filed. The affidavit of the respondents has not been filed, Lordship. On 6 occasions, they have sought for time, Lordship.
Mr. Kosek,
Elementary.
where is your affidavit?
Yes, I just give us 3 weeks to file our.
Pardon?
3 weeks time to file our.
But in the meantime, several opportunities have been granted to you.
We have not received the bill instruction. Give us the last step.
All right, I am granting you time, but you pay some cost.
As a
So
last.
this way cannot be allowed to continue.
2023. Lordship will give us 2 weeks time, Milord. I'll get sure, Milord.
Part Mr. Day, learned counsel for the petitioner, and Mr. Kosik, learned standing counsel for the elementary education department. Mr. Day has pointed out that in spite of granting several opportunities to the respondent authorities, no affidavit in opposition is being filed till date. However, Mr. Kosik, learned standing counsel for the respondent authorities, submits that he may be granted 2 weeks time to file the affidavit. There is allowed, however, a sum of rupees 10,000 they deposited in the welfare
As a
fund.
last chance, Milord. If not, Milord, your Lordship will proceed without
No.
the affidavit. Or, yeah, subject to not filing, Milord, will pay the cost.
Deposited in the welfare fund of the Guwahati High Court Employees Association within a period of, no, before next day.
Lordship, kindly fix a date in the
List on
21st after
21st.
most obliged. Timing item 22.
May I please? My document. Regarding my lord, deposition of cost by the other side, my lord, they will
We've received instruction, Lordship, that the department has started the procedure for disposal of the cost amount. If the Lordship would kindly grant us about 4 weeks time so that the money reaches, it can be deposited. They have gone through everything. Hear from them.
No, we have already granted you time.
let me start with the case, my lord, and
If you are not intending to comply with the order of this court, we will register a suo motu contempt petition. We will register a suo motu contempt petition against the respondent.
Lordship, my information, sorry, my instruction, Lord, and what I've conversed with my senior as well, but is that they've already discussed the amount. This hasn't reached. They've completed all the procedure that they have internally. So that the money is.
Where is Mr. Somoa?
Lordship is, I think he's just left the campus for something.
And where is the affidavit in opposition?
they have just stated their stand, my lord. In the affidavit of opposition, they have filed.
Who is for NCT?
NCT master, ILM will come, my lord. He has informed me. ILM will come.
So whether the matter is ready for admission hearing now?
Yes, Lordship. Yes, buildings are exchanged already and it's ready for disposal.
Then all the parties are available here.
Yes, second education is there.
Then NCT, Council for
NCT,
NCT.
NCT, Mr. Ayala will come, my lord. He has
Hmm?
already informed me.
Let Mr. Alam come. Forward it, forward.
File numbers 27 and 28.
My lord, here, this contempt your lordship may recollect.
So before my correctly start, the I pray for an accommodation. This matter come up on 11th. They filed one affidavit reply, otherwise also not on record. I'll need to take.
We already served on that. Well, that was already served on them. Only thing clarifying the position. Nothing very important is there. Lordship may recollect that the division bench of this honorable court directed that those candidates who have passed CTET, central TAT, they should be allowed to participate in the recruitment process in the year 2020. 2020 pursuant to an advertisement. They went to Apex Court dismissed the SLP in limine. Thereafter, they sat tight, didn't do anything. After long persuasion, contempt and all, they issued some advertisement whereby they showed that there was no post lying vacant. So we had to come again under it, and the collateral bench of this honorable court directed that no, you will have to process out and accommodate them. As per the recruitment notice circulated in 2020. Now, they have, Lordship may recollect, the director was also asked to appear here, and the director appeared. The commissioner secretary also appeared. And thereafter, they have made appointment to 187 candidates. But regarding 50 candidates, they now say that we cannot accommodate them because we are examining their certificate pertaining to DLN because it was obtained from National Institute of Open Schooling.
18 months DLED.
Now, under the present situation, because they say that they issued affidavit they issued notification, director's notification they have referred to, wherein they say that that as per that notification, Lordship will kindly take up their
But
affidavit.
the affidavit filed by the respondent is not available on the record.
It is on record, my lord.
Sorry.
Our reply is not that material. Lordship, if Lordship finds that their affidavit is enough to show that it was complied with, then of course things will differ. At page 120, Lordship will find their affidavit. It is submitted by
You will see the last date of. 25/9 and 15-day order.
Okay. Okay, it is in different file.
What is that?
Page 126.
This is the affidavit coming from the director now.
Hmm.
After now, here. Paragraph 4 is relevant. Paragraph 4.
Hmm.
It says that thereafter, out of 237 selected candidates, the appointment letter of 187 candidates were published and made available in the official website of Directorate of Elementary Education on 24/09/2025. And the same was also produced before the Honorable Court on 25/9/2025. 24/9/2025, they have issued it, and 25,
they produced when they appeared personally, which is retained in the record. Now see, but the appointment orders of remaining withheld 50 candidates could not be published as the verification undertaken to check their working status as per the existing law in force and as per notice issued Vida deed Assam number so and so dated 17/6/2025. Due the interim order passed in WPC so and so, Rupam Roy so and so, so and so. Now, can it be the ground? In 2020, pursuant to the advertisement dated 2020, they have decided the eligibility. And thereupon, there was no such question of NIOS certificate that time. How was they procured, that was never the issue. And they have accommodated all. But they denied us because we didn't have the state TAT qualified certificate. We had the central TAT qualified certificate. They said you cannot participate. Court said that no, you cannot deny. You will have to accommodate them, consider them. Therefore, now how come they, on the basis of the notification, the 17/6/2025, take this plea that now this is an issue which we are required to look into, and thereafter only we can judge their eligibility. Does it leave any scope to them to decide the eligibility when the court has already held? Well, in the contempt petition at page,
Whether that interim order in WPC number 3794 of 2025 is part of this affidavit?
whether that,
Interim order is in WPC number 3794 of 2025 is part of this affidavit?
no, it is not concerning us. Some of the candidates, NIS certificate holders, they approached the court. In that, there was initially a stay order. After the stay order has been vacated, they have gone on appeal. The writ appeal is pending now. That is the position. Because in the recent notification, in that director's notification, there is 76/2025, they have shown that NIS certificate holders should clarify certain aspects pertaining to their availability at that time in the school, how the certificates were issued, what was their attendance, what amount did they draw as their salary from the school. Certain requirements they have fixed. They challenged. NIS candidates, they challenged before this court. Initially, stay was granted, subsequently vacated, matter is before the division in appeal. But we are not the party. Our case was already decided in pursuant to 2020 advertisement. It was upheld by the apex court. Can they raise any new plea that today they are not qualified?
Situation has changed.
Situation has changed. Today you are not qualified, or you will have to justify, otherwise we will decide your eligibility now. Can it be so? This is not the law. I wonder how the state is playing with it. I wonder simply, my lord. When the court has already, the other day I submitted, if they have a case, they can say, you are all appointed, taken. Subsequently, they may take a call. That yes, we have verified, we have found that time you obtained the certificate by playing fraud. Why not you will be terminated? That is another case. But can they sit over the decision of this honorable court? Division bench decision, single bench decision, upheld by the apex court, and now say that now we are raising this issue in respect of those 50 candidates. In my full submission, this is totally unjustified. They cannot sit over only in contempt. What remains? No question of law. Their question is whether you have complied with or not. If they show that yes, complied with, then that's all. Can they take some new point and go on arguing that now law has changed, now we cannot under the present law accommodate them? Whereas when the 2020, when you issued the advertisement, those were not the issues that time.
Supreme Court also clarified.
And the court has already taken the call, decided in our favor that time, taking the law at that time existing. Therefore, now it is 2025. Our decision was rendered in 2023. 8 August 2023, it was decided.
This Supreme Court also clarified in NIA Dropa it unfortunate, the needless to state that a clarification will be effective on the date of pronouncement of the judgment under it. Is 18 months period.
And my lord,
I've given a copy.
Lordship may take up the decision of the apex court.
Everything came up.
Copy has been given
Vishwanath.
where
Vishwanath and other.
Vishwanath and others, they approached the apex court
Review.
seeking review of the
18 months period, and then to the-
order of the apex court which was issued pertaining to the NIOS certificate holders.
The other issue has come up.
DLED issue has come up. There,
There are two.
Lordship, it was clarified by the apex court at paragraph 3. However, to avoid any confusion, we again, Lordship got it, Malad? Yes. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. The question was, question was raised that otherwise DLED course is 2 years. Those courses were imparted by the colleges here under the state government. But that time there was no sufficient college. Therefore, all the persons could not join. So, what the government did, government issued a notification asking that the NIOS, National Open Schooling, will conduct a course for those working candidates who were already working in the field of teaching for them, and this course will be 18 months duration. And candidates have joined that course and cleared the examination within 18 months. Subsequently, some people raised the question that we have passed 2 years course, how can they compete with us having taken the degree of 18 months course? This was the question raised by some of the successful candidates in DLED 2 years course. Therefore, ultimately, we went to the apex court. Apex court said initially that it cannot be treated as similar or equivalent initially. Then, thereafter a review petition. In the review petition, court has clarified this. Now, kindly see, 3 has already clarified that it would be who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. They can apply elsewhere. It will be treated as valid. Initially said, no, it will not be equivalent. It cannot be treated as valid as against the 2 years course. That was the view. Then again it says, needless to state that the clarification will be effective from the date of pronouncement of the judgment under review.
In 2020.
So this clarification comes and becomes effective from 10th of December 2024. Not prior to this. Ours was decided in 2023, the apex court decided.
Recruitment of 2020.
Recruitment of 2020. There, they have, when they again undertook the process of selecting or appointing these persons who were left out under central government CTET, they have issued a notification that Lordship may see, they have referred to what? In affidavit, which one? Itu nahi neki that. Itu kontut? Oh, it is annexed to our reply affidavit, but reply affidavit has not come as.
Not available here.
Not yet. This is an advertisement dated 2022. dated 4th May
Do you have any
2022.
extra copy? You
Yes,
gave me?
extra copy আছে নে? No? Lordship may see this. দি দিব লাগিব। এখন মাৰ্ক চাৰ্ক কৰি অৱস্থা নাই। পঢ়ি দিব পাৰিবানে? Lordship may see from this, my copy.
But how can you argue then if
We
two
have
copy
a
is
soft
not
copy.
available?
Lordship, we have a soft copy.
In fact, in the first instance, my client senior said that this affidavit is not even relevant. May not have.
No,
to do it.
affidavit is not even relevant in the sense, contents are not that, but that advertisement is of course a part of their record. What I have stated there, it is not material. 170 page, Lordship will find it.
Yes.
That is an advertisement issued by them on 4th May 2020. First paragraph itself, Lordship may, these are marked, I cannot read, just read it. Yes, sir.
In compliance of the Honorable Guwahati High Court order dated 3/2/2021, passed in writ appeal number 24/2021, and order dated 12/2/2021, passed in IA Civil so and so, and contempt case number so and so out of writ appeal number so and so, along with
Appeal number?
writ appeal number 24/2021, along with IA Civil and Government Elementary Education Department Assam Instruction Right dated 8/10/2021. Online applications are hereby invited through the official website of DEE Assam, that is so and so, only from the writ petitioners involved in the concerned writ petition and fulfilling all other eligibility criteria for filling up of remaining vacant posts against advertisement dated 11/9/2020.
11/9/2020. Against that advertisement, they wanted us to again submit their applications.
For a post of assistant teacher of LP schools and assistant teacher of UP schools under Director of Elementary Education Assam.
This is, and then criteria Lordship will see there, B, serial number 8. Yes.
The eligibility criteria Lordship of finding, specified in the advertisement dated 11/9/2020 will be applicable except the criteria of Assam TET, and all other eligibility criteria must have been obtained on or before the last date of submission to online application as per the said advertisement dated 11/9/2020.
11/9/2020, that is the cutoff date. That you must have all qualifications and requirements as per that advertisement dated 2020.
11/9/2020.
Now, how can they say that recently another notification issued or some law has come imposing certain checks? Those are not applicable to us. You cannot hold us back, our cases back on that ground. Because our case is already decided. You will have to comply with it. Compliance is not raising questions. Compliance is not re-examining the orders. No, that power is not given to the state. State will have to simply comply. They will have to follow and act in accordance with the direction given. Therefore, my responsible submission, there is no ground at all to hold it back. They are holding them back, these 50 candidates. They cannot be made now to clarify points because they were held to be already eligible. And their respondent was directed to appoint. That being the position, now even they cannot ask, you give these certificates or that, and whether you are qualified or not, we will examine now. No, that is not given. Therefore, my responsible submission, only way out is to comply with, then say, if they have any cause subsequently to be taken against those employees, then they will have that. I am indicating on their behalf. Somebody cannot play fraud otherwise. Then you may have a call, you may take a call. But having gone up to apex court and the judgment is affirmed, you cannot say we will not comply with it. Law has changed. No, you cannot.
And with regard to the LP portion, we have allowed. Nowadays, not an LP portion.
Yes, Mr. Kosek, what is your stand?
My lord, the order against which a contempt is alleged, your lordship will see. There was what happened, my lord, upholding by the apex court was a completely different issue. What happened, my lord, initially, the initial advertisement of 11/9/2020, my lord, where the seated candidates were debarred from participating in the recruitment process. That was challenged before this honorable. This honorable court, the honorable single judge dismissed the writ petition, it went to the writ appeal. In the writ appeal, the honorable division says that as the candidates, the writ petitioners and the writ appellants are 916 in numbers, so therefore, in 2 phases, the recruitment has to be completed. For the 916 candidates who had seated, for that very recruitment process, they were allowed to be participated. And that went to the Supreme Court. Supreme Court has have not decided the issue raised, saying as it is confined to only 916, therefore it should be proceeded for recruitment. Now this division bench direction was complied by way of an advertisement, my lord, and pursuant to that advertisement, which my senior has just known, pursuant to that advertisement in respect of 916, the applications were called. The petitioners along with the other candidates, they applied, and there was a subsequently the breakup list. The vacancy position was declared, and in the vacancy position there was no general category post available in the vacancy, which was put to challenge, and the order passed in that writ petition is a subject matter of contempt. And in that writ petition, my lord, will kindly see paragraph 19 and 20. What was the direction?
Page number?
Please. Paper name of file. I'm sorry, my lord, like.
Okay, is it the order dated 8/8/20?
8/8/2023, yes.
Okay.
Now, my lord, will kindly see paragraph 19.
Yeah.
In view of the aforesaid discussion and the background facts and circumstances, this court is of the opinion that a case for interference is made out. This court therefore issues the following direction, which should serve the interest of justice and also equities can be balanced. The state would have the option to carry out an exercise of for de-reserving the numbers of posts in which the present petitioners and the respondent number 3 to 7 are required to be considered in accordance with the earlier direction of the Honorable Division Bench in judgment dated 3/2/2021, with a stipulation that a de-reservation would be later on adjusted in subsequent recruitment process. The said exercise, if decided to be undertaken, is to be completed within period of 3 months from today. If the aforesaid option is unavailable or unable to be complied by the state, the respondent authorities are directed to offer appointment to the petitioners after consideration of their position in the select list, and for those petitioners, including the respondent number 3 to 7, whose positions are above. Any candidates who have been offered the appointment, the last of such candidates should make way for the appointment of the petitioner. The aforesaid exercise, however, is to be done issuing a notice to the affected candidate, and appointment have to be offered to the petitioner strictly based on their position in the select list prepared in the pursuance of the initial advertisement dated 11/9/2020. So, my lord, in this petition, the issue was with regard to the vacancy position. Now, my lord, subsequently the state has accommodated and has issued 187, not 187, my lord. Total would be 194. 194 appointments has already been made. Now, in respect of the 43 candidates, 43 candidates, pursuant to the judgment of this Honorable Apex Court in Jaivir Singh, where it has been declared that the 18-month DLA would not be valid. Now, in the review, my lord, it has been said it will have a prospective operation. Now, the notification, my lord, which we have indicated in the in paragraph 4, my lord, 17/6/2025. A process was undertaken by the government to check whether, because the 18 months DLA was valid only for the person who were in service while acquiring that degree. Now, this 17/6/2025 notification was a verification process to check whether they were working at that point of time when the DLS degree was obtained. Now, this 17/6/2025 notification was a subject matter of challenge in the writ petition before this Honorable Court. the Honorable Court has upheld that decision, saying it is in consonance with the direction of the Honorable Apex Court. Now, while verifying in terms of that notification, it is found, my lord, that these 43 candidates does not fulfill the criteria that is mentioned in the notification, and they could not produce anything which shows that they were in service when they have acquired this DLS certificate, 18 months DLS certificate. But it is not that we have debarred all 18 months DLS candidates from the appointment. Those who satisfy that they were working while they were when they have acquired this degree, they have got this appointment. But among these 294, among the 194 who have been given the appointment out of that merit list, my lord, among them there are 18 months DLA also. So, in respect of this 43 candidates, my lord, we have withheld, and there is a speaking order also, I guess, my lord. Therefore, I wanted to take an instruction, my lord, that we have rejected their candidate. Well, the direction of this Honorable Court against which a contempt is being alleged, well, that direction says that if there is no post, then the state will have to de-reserve the post, or state will have to create post for completing the process of the recruitment that was undertaken by the advertisement. So, in my respectful submission, my lord, the completing the recruitment process now is amounts to compliance of the order, because the recruitment process is completed by appointing 194 candidates. Appointment order has been issued. They have joined their service, and with regard to some candidates who could not be appointed, and they have been rejected. Now, that
whether such
rejection, whether would be correct or not, that perhaps would be a matter of, well, challenge in where the appointment rejection is concerned.
no, whether such option is given in the order dated
So the order dated, the order against which the contempt is alleged, does not say that everybody has to be appointed. It says, the issue before the court was that whether there are vacancies available or not. Even if there is no vacancies, then the state will have to undertake some exercise and create vacancy or de-reserve the vacancy, and to complete the process of recruitment.
But such option is not given to you in this order dated 8/8/2023.
Well, that option is also not curtailed, my lord. Because
in that way, the
recruitment,
court's
my lord,
order cannot be interpreted.
no, my lord, the Honorable Court has directed us to complete the recruitment process
By appointing.
by appointing, and the appointment has been made. And certain persons, my lord, who would not be appointed, they have been rejected by a order.
And where is your speaking order?
My lord, therefore, I paid for taking up this on 11th. In the first, my lord, before my senior started, I had prayed for an
No. Then what affidavit you have filed? If you were not enclosed the speaking order with your affidavit?
No, my lord, later on, because the affidavit, my lord, where on that day, till that day, there were 2 more verification left, my lord. In the affidavit, we have said that. Lordship will kindly see. In fact, in the last order, my lord, you kindly see your order of 15 days. Last order.
Okay, let there be further hearing on Monday that. Yes, ma'am. Mr. K.K. Monto, learned senior counsel, assisted by Mr. K.M. Monto, learned counsel for the petitioner, and Mr. P. Kosik, learned standing learned counsel for the contempt action. Please the matter for further consideration on Monday. 10th. Monday. 10th.
Wednesday.
Wednesday at 2 p.m. at 2 p.m.
On 12 November, when is this?
In the meantime, Resi shall take the affidavit filed by the petitioner hearing, affidavit in reply filed by the petitioner hearing with the record. This accordingly.
Timing 22.
Apply.
May I start? Ma'am? The petitioner, my lord, is qualified for the post of subject teacher, my lord, in the subject of zoology. And therefore, my lord, she has initially participated for HS TET examination, my lord. And HS TET advertisement, your lordship will find at page 59. This is the HS Annexure 3, page 59, my lord. This is the advertisement allowing the candidates to participate. Those who are having the master degree and B.Ed, they can participate, my lord. Accordingly, the petitioner participated and she has passed. Page number 64 is the pass certificate. But the NCT is the authority, my lord, which determines the minimum standard for teaching staffs, my lord. And as per the NCT norms, my lord, it is notification is at page 65, Annexure 5, my lord. It is a postgraduate, page 67 is a relevant portion, my lord. Senior secondary schools, intermediate. Postgraduate with at least 50% marks from recognized university and Bachelor of Education, B.Ed from National Council of Teacher Education, recognized institutions. And the petitioner duly possesses, my lord, and she has been thereafter, my lord, the advertisement has been issued for recruitment to the post of higher secondary subject teachers in different subjects, my lord. And petitioner participated, and she also, my lord, got selected. She participated in the interview, my lord, and she got selected. And ultimately, she has been appointed. Appointment order was issued at page number, my lord, the appointment order. Appointment madam order, my lord, at 155, page number 155. He has been appointed as
Page number.
page number 155, my lord, Annexure 19B. He has been appointed as PGT Zoology.
Page number
155, my lord. This is the second round of litigation, my lord. Earlier, there was a writ petition by the petitioner, my lord. And in that writ petition, my lord, before the division bench, it was before the division bench because we put to challenge the service rule of 2018. And in that writ petition, my lord, there was interim protection to the petitioner. And due to that interim protection, my lord, petitioner ultimately got selected and appointed. What happened, my lord? He was not allowed to join, and the university, Assam University, Silchar, as well as the, my lord, department has brought into record two opinions of the experts. Experts, my lord. Issue mainly is pertaining to whether candidates having life science subjects like microbiology at the master degree level would be eligible for appointment, my lord, in the subject of zoology PGT. Your lordship will find that the central government schools, my lord, KBS and my lord NVS, Kendriya Vidyalaya Sansthan and my lord NVS, they issue advertisement, they also issue such advertisement for the postgraduate teachers, my lord. Your lordship will find at page number 73, relevant portion.
No, you have been appointed, but you have not been allowed to join.
Yes.
Thereafter, what happened?
Thereafter, my lord, they have brought one expert opinion against me,
Oh.
the department.
Hmm.
That is put to challenge here. As because they
Where is that?
that I will take your lordship after, before that I take your lordship the other documents, then it will be easier, my lord.
You first show me that document.
Yes, lordship. Well, I take your lordship to page number 139 first. Sorry, well, 158. This is the affidavit in opposition filed by the Assam University, my lord, wherein they have annexed the opinion of the expert committee, page number 165. This is the expert committee constituted by the university, comprising of 5 professors. Department of Life Science, 2 professors. Department of Microbiology, my lord, 2 professors. And Department of Life Science, another professor, member convener. This is the next page. You'll also find page number 166. This is the opinion of the expert committee constituted by the university. The meeting was held in the office of the Department of Life Science and
No,
Bio.
I am asking you the expert opinion obtained by the respondent authority.
Impugned, my lord.
Yes.
It is page 166, my lord. 166, just a minute. One 142, my lord. 142. In this, my lord, your lordship will find they have without taking consulting with the, my lord, university level professors of the microbiology as well as life science experts, my lord, the respondent, what happened, my lord, over telephone consulted with one assistant professor of the college who are, my lord, in the higher academic institution, they are in the lowest level. They have consulted, and that too with the subject of only zoology. And they have over telephone, my lord, discussed and issued this impugned opinion. Assistant Professor, Department of Zoology, and Assistant Professor, Department of Zoology, my lord, both B. Bodua College. They cannot be treated as experts because, my lord, the university level experts are required. Earlier occasions in respect of my lord biotechnology subject, a similar case has been there before this honorable court, and this honorable court also disposed of. I'll take your lordship to the orders, and thereafter the authority has constituted the university level committee, and university committee, my lord, after examination has accepted that the biotechnology master degree holders, they can apply. Presently, my lord, the earlier biology subject was divided into two streams, only zoology and botany. Now it has become 16 subjects. All are allied subjects. And all the subjects are and equivalent. And in order to cope up with that development, scientific development, my lord, this dynamic concept of has incorporated. Page number 98. Your lordship will find. 98 is the order starts from 91. 98 is the relevant, my lord. There was earlier round of litigation by the students of biotechnology department. With respect to, my lord, appointment of assistant professors in botany. And page number 99, another writ petition, my lord, before the division bench, 7146, with respect to zoology. Zoology in BSc and having the candidates having master degree in biotechnology. This honorable court at page number 102 has given the direction, my lord. Accordingly, the present petition is disposed of, directing the respondent authorities, more particularly the respondent number 1, to constitute an expert committee, which may also consist of academicians who are experts in the field of biotechnology, who may decide as to whether the postgraduate degree of MSc in biotechnology is equivalent to MSc in botany, so that in the event it is decided by the expert body that postgraduate degree or degree of MSc in biotechnology is equivalent to MSc in botany, the petitioners would be eligible for applying for appointment to the post of postgraduate teachers in botany, as and when subsequent advertisement is issued for appointment to the post of postgraduate teacher in botany. If the state government feels the need to include any expert from university, they may do so. Accordingly, my lord, the expert committee is constituted. It is at page number 108. University level experts committee of comprising of 7 members. Annex 10, page 108. And recommendation is page 109. The expert committee constituted by the government in secondary education department by notification number and as per direction of the Honorable Guwahati High Court in WPC number and in the meeting of the expert committee held on Auto, has resolved that candidates possessing BSc major honors in botany with postgraduate degree in biotechnology are also eligible to apply, with candidates having MSc in botany for appointment to the postgraduate teacher in botany, as and when subsequent advertisement will be issued by the government in secondary education department for selection and appointment to the post of postgraduate teacher in botany. That candidate also appointed subsequently the petitioner. And annexed 11, page 111, my lord. This is the notification in respect of Tripura government, my lord, for the post of where it is also said MSc Molecular Biology and Bioinformatics will be considered as equivalent to biological science or postgraduate teachers, provided the candidate is having any of the following subjects: botany, and zoology, human philosophy in their graduation. MSc Biotechnology will be considered equivalent to biological science for the post of graduate teacher, provided the candidate is having any of the following subjects: botany, zoology, human philosophy, physiology in their graduation.
So here no direction was issued for constitution of expert committee.
Here, in this case,
Yes.
in this case, my lord, in the division, while the case was pending before the division bench, my lord, they have themselves without they constituted the committee, my lord, and they have issued submitted the impugned opinion before the division bench, and as therefore the impugned opinion we have to challenge here. That's why this petition has come, my lord.
What happened in division bench?
Division bench is closed with the observation granting liberty to the petitioner to challenge before the appropriate authority.
Yes, what is your stand, Mr. Alam?
So far as NCT has no rule, but however, my understanding is that the regulations of NCT. If I there is the required qualification at
Page number
67.
7.
Postgraduate with at least 50% mark, that is in respect of senior secondary education for class 11 and 12. From the recognized university lecturer of 36 years of federal constitutional certification, recognized it. The postgraduate degree with at least 50% marks for his experience of the recognized teacher may appear and SC here from any recognized. That means where it refers we are taking by the from the recognized teacher. And another aspect, my lord, gone through my lord, case number, my lord, filed by the ATC method. Here, my lord, I have found case 301. That is in the school public UBC. One. Submitted by the university.
Yes.
The university grants company specifies it is a defined under the of the such degrees can be awarded by the university completed by or under the government act or official act or state act or by any institution under the equivalence of degrees from a certificate are not determined by the university. In case of higher education, equivalence is by the university and the case of employment promotion by the employee. That means it is the possibility of the case. Since she had the diploma and postgraduate diploma and microbiology, MSc in microbiology. The NCT has also in the respect of we have issued the guidelines method.
Your lordship will find at page number 115. This is the biotechnology with zoology. Earlier one, my lord, biotechnology with botany. Graduation in botany and biotechnology master degree that is accepted by the government. Now at page number 115, my lord, it is graduation in zoology and master degree in biotechnology. That is also accepted. Page number 122, your lordship will find this one candidate certificate, my lord. He has ecology and environmental science. He is master degree in Master of Science in Ecology and Environment Science from Assam University, page number 122, my lord. And 121 is appointment order for zoology. Name Shumonde, page number 121, annexure 13, my lord, serial number 10. He is zoology and his subject is, my lord, ecology and environmental science. Actually, what happened, my lord, earlier only the concept of zoology and botany was there. Now it has become widened. And as a result, this is not in respect of one case, my lord. As a result, my lord, UGC has formulated the guideline of, my lord, net examination. Net examination, my lord, it has got the subjects. I take your lordship to page number
No,
100.
how it is relevant here?
Relevant means, my lord, you are taking the
So,
TET
okay.
examination and net.
So Sarma, this committee was constituted somoto. Annexure 18B, page number 142.
Department has constituted the committee.
Yes, there was no direction of this court or from any other sources.
There is that circumstances arising out of subdivision number 2 and 5 rights. Timothy Alakanam Dasgupta requires the Department of School Education to constitute an academic
No,
committee for determination of equivalency between the master's degree in microbiology with a BSc degree in zoology and degree of masters in zoology and allied subject for the post of postgraduate thesis of zoology was discussed in detail. So in the context of that repetition matter, this committee.
no, there is no direction of this court.
There was no such direction of disposal. It was they themselves had initially. And likewise, the Assam University at page number 166, they have also constituted, my lord, the expert committee of professor level. Having the experts from microbiology, having the experts from, my lord, life science, and having the experts from, my lord, zoology. Here,
Where is Mr. Kyle?
Assam University, my lord,
Pardon? Can you argue the matter?
four point 161, my lord, in the writ petition. One 61.
Four point?
3, well, here.
So, Mr. Sharma, so which report of the committee the court will consider? The report given by the university or by the professor, assistant professor of Bibura College?
Regarding that question, my lord, in our affidavit, we have mentioned that we have consulted with the, Guwahati University also, and we have the,
Affidavit page number
our affidavit start from 229.
229. You have consulted the Guwahati University.
Guwahati University.
Where is that report?
232, page number 232, paragraph number 89.8. And sign given humbly begs to state that the academic register in charge of Guwahati University writes the lesson number so and so. There is 25/7/2023 mentioned that the MSc in microbiology is not equivalent to MSc in geology. So here our letter is 236 page from Director Secondary Education to Guwahati Register, Academic Register, Guwahati University, with reference to the subject 236 page. With reference to the subject cited above, I have honor to state that as per direction of the Honorable Guwahati High Court, right order that 16/3/2023 passed in WPC 1489/2023, the undersigned is in need of a clarification whether MSc in microbiology is equivalent to MSc in geology or not. Therefore, you are requested to kindly clarify as to whether MSc in microbiology can be treated as equivalent to MSc in geology or not. The matter is distributed on our course. Thereafter, my lord, the academic register has written to the Director of Secondary Education in inviting a reference to the subject cited above. I would like to inform you that MSc in microbiology is not equivalent to MSc in geology.
So what is the basis of this opinion?
This sort of
Please.
Regarding the order dated 16/3/2023, passed in WPC 1489/2023.
No. On what basis this academic register has given this opinion?
I am not aware, I have no knowledge about this, madam, because it is a matter of Guwahati University and academic register has written to
No,
us.
going by this letter, can it be said that he has consulted with some expert in that line?
But their view is that MSc in microbiology is not equivalent to MSc in geology.
That's all right, but what is the basis of this opinion? Whether academic register can give such a
So
opinion?
counsel for the Guwahati University may be better person to replace. Guwahati University, Malin Moha, autonomous body.
No, is there any dispute that Guwahati University is not an autonomous body?
No.
Then? My question is simple. On what basis the academic register has given this opinion, whether he obtained any opinion from any expert of the university or not?
Regarding that, my lord, there also no another documents or other documents as annexed.
Right.
Mr. Fukan is available in the court? Not available. Can we go for a new committee comprising of some members of the university?
Yes, Lordship. Of the university in the relevant subjects. It has to be from the relevant, both zoology and life science and microbiology. This subject should be considered too. Otherwise, my lord, it will not be fair and proper, my lord. Because in earlier occasions, my lord, they have done. In respect of biotechnology, when they have government has constituted the committee, universal professors, 7 professors, they have considered from different life science departments, and they have done it, my lord. Assam University has also, my lord, from the taking the opinion of 5 professors of the different life science departments. And only zoology, that will not be, my lord. That it should be covered university level professors of, my lord, life science subjects, including microbiology, zoology, both. Because life science concept has become vast, my lord. Nowadays, it has become widened, and this, total 16 subjects have developed, my lord, though they are interrelated. You will find in page number 178. This is the syllabus, my lord, for the set examination. Botany. What is botany? It is given. What includes botany, my lord? It includes biotechnology, microbiology, molecular biology, biochemistry, bioinformatics, ecology, environmental science, biophysics, numbers of subjects. And also in page number 180, you will find zoology. It is in the right 180 right side. It is given all science subjects having application in zoology. These are this net set examination syllabus. All life science subjects, all subjects having application in zoology. Only common examination. TET examination, government has conducted common examination, life science, life science. It includes several subjects.
So do we dispose of the petition by directing the respondent authorities to constitute one expert committee?
Of the university level professors, comprising of university level professors.
Yes. Whether, or should we keep the matter pending here?
Dispose of, lordship. Dispose of, and she has been appointed, my lord, already, but could not join. So, my lord, if she is in the meantime allowed to join, and that will be subject to
No.
outcome of the.
No. Unless the report is available, how can we direct?
And then
to such a direction?
her appointment should be subject to, my lord, the outcome
No.
of the expert committee's opinion. And I have given the judgments, my lord, annexed with the writ petition itself, my lord. 3 judgments. I am giving the relevant pages, my lord. 198. There is one judgment. Page number. The similar line, my lord. May I read, madam? In view of the other contentions of the learned counsel for the petitioner, the court finds that the determination of equivalence of subjects at PG level, which is the specific domain of the 4th and 7th respondents, but not the 2nd respondent, which is either expert body, which neither expert body nor competent authority to decide the equivalence of subjects at PG level. It is settled and recognized under law that the University Grants Commission is the competent authority to declare the equivalence of subjects at PG level. More particularly, it is the domain of the 7th respondent, but not the 2nd respondent. That the other contention of the council that the MSc Bioscience of other universities are also notified, recognized as equivalence to MSc Zoology is acceptable and tenable. In view of the specific notification by the 5th respondent regarding PG subjects, which are excluded from the equivalence of MSc Zoology, and subject courses of other universities are not excluded is also considered an acceptable. Since the fourth respondent is the deemed university and particular bioscience course consisting of botany and zoology as per the certificate. I'm reading paragraph 23. The other contention of the learned standing council that the petitioner does not possess the degree of MSc zoology or any other recognized equivalent certificate. He cannot teach the subject zoology to the students is
No,
all.
now tell me whether there is whether we will include the expert of UGC and NCTE in that committee?
Yes, it was, my lord.
Do you have any experts?
Here it is this, a central university, Assam University, they have given the opinion. But the university, UGC,
And UGC?
Supreme Court has stated, my lord. I'm giving the orders, okay, next also. And UGC guideline, your lordship, I have annexed, my lord. It is at page number 20 to 220, last page. Earlier, my lord, in the 2010 UGC regulation, it was equivalent, concept of only equivalency was there. Now, in the year 2018, it is widened. It has, my lord, what is equivalency? It is elaborated. Concerned, relevant, and allied subjects. Page number 228, UGC regulation, my lord, 2018, clause A, last paragraph. It is concerned, relevant, and allied subjects. Earlier, only equivalent concept was there. And in that line, analyzing this provision, Honorable Rajasthan High Court has given the judgment that I have annexed, my lord, before that. Page number 212. Exactly in the similar, more or less similar issue, my lord, equivalency. Microbiology is also discussed here. I read from, my lord, page number 221. Having, page number 221, second paragraph. I read from second paragraph. Analysis between the 2010 regulation and 2018 regulation.
First, tell me whether there is a requirement for incorporating the expert of UGC in the committee.
Yeah, lordship, but it's direct, my lord. It will be better.
Yes.
Expert of UGC and both NCT, my lord, your lordship may also direct. Because they are the authority, they can give. I just read, my lord.
UGC.
I just read, my lord, the page 21.
Whether such UGC experts are available in Guwahati? You have to see.
My lord, I just read, my lord, 221 page number, second paragraph. Having heard the learned counsel for the parties and having perused the documents on record, what emerges is that the UGC regulation of 2010 eligibility criteria prescribed for appointment to the post of assistant professor was master degree in the relevant subject with minimum marks or grade. The materially changed by virtue of the UGC regulations 2018 in which the eligibility criteria prescribed for the said post was master degree with 55% marks or equivalent grade in concerned relevant and allied subjects. Earlier only equivalent. From an Indian university or an accredited foreign university, the eligibility criteria and consistently the zone of eligible candidates was widened by substituting the requirement of holding the master degrees in the relevant subject to holding the master degree in the concerned relevant and allied subjects. And this is the my lord statement opinion of the Honorable Rajasthan High Court from the my lord UGC regulation 2018.
Regarding the appointment.
Allied subjects, my lord, the concept of allied subject has been incorporated in the year 2018 in the UGC regulation. An allied subject includes in respect of zoology or botany, my lord, all the subjects which the UGC and the SET commission, my lord, has incorporated for the net qualification in the life science subject.
Okay. Can you ask Mr. Somoa to remain present in the court tomorrow?
Regarding this, I want to add one point on here. Hello. In our affidavit, paragraph number 4, my lord. That the petitioner is a master degree holder in microbiology with a BSc degree in zoology. The petitioner claim for selection of post of a teacher in pursuance of the recruitment notification dated 27/12/2022. However, her appointment was stayed, citing the master degree in microbiology being held by the petitioner is not treated as equivalent to degree of masters in zoology. Was treated as equivalent with a MSc in biotechnology. The qualification process for the selection in question was closed on 17th June 2023. And my lord, here in paragraph number 6, my lord, the office by letter number so and so dated 35/2020 directed the inspector of schools KDC Koringons to withdraw the name of the petitioner as the post graduate teacher in zoology from the provisional appointment letter.
Yes.
One. Page 234. With reference to the subject cited quoted above, I am forwarded here with a copy of the Honorable Court Order 15/2020 passed with 14/89/2023. However, the Honorable Court directed the petitioner may be allowed to professionally participate in the ongoing selection process. However, the result of the petitioner shall be kept in the seal cover and will not be declared without the of this process.
But they have appointed, my lord, in spite of that. And my lord, they have written to the IS. IS has not withdrawn my name from the appointment order as on date.
Okay, let it be tomorrow. You ask Mr. Somoa to remain present. Heard Mr. Professor Learned Mr. U. Sharma, Learned Something Council for the Secondary Education Department. Mr. I along for the Learned Something Council for the NCP. Miss Learned Council appearing on behalf of SC Kyle, Learned Something Council, Assam University, and Mr. Arbuya, Learned Council appearing on behalf of Mr. A. Soma, Learned Something Council for the 45. List the matter tomorrow for further consideration. Mr. Bhuya, Learned Council appearing on behalf of Mr. A. Soma is directed to ask Mr. Soma to remain present in the court tomorrow.
Obliged.
Please, Your Lordship. This is a 2016 contempt matter. I mean, on the last occasion, my learned colleague for the Pension and Public Grievances Department was directed to place the instruction regarding compliance of the order. Probably he's got some instructions.
I was to place a compliance report without bail, but honorable court during the last time. However, your lordship have listed detailed instructions, lordship. So which says that some more exercises are yet to be, so in that instance, your lordship.
What exercise is required to be made?
Yes.
Yes. Yeah, the third party.
The pension proposal was not submitted earlier.
Lordship, it was. It was submitted indeed, your lordship, which is that on scrutiny of the available reports, it has been found that initially the special family pension was at 2661 and later on revised at rupees 2811, which has been verified and found correct. It is pertinent to be stated here that the said amount of special pension issued by the directorate had been fixed based on the last basic pay drawn by the deceased pensioner, which did not include any promotional benefit, increment benefit, and other allowances admissible to the deceased husband of the petitioner. This director has not yet received any pension proposal as per government poem dated 26/8/1985 issued by the government of Assam in the finance department pension run for revision of special family pension from the inspector. So to that effect, your lordship, there's communication, other communication that they have requested the inspector of schools that in terms of that government OM dated 26/8/1985. So they have sought for that, your lordship. So your lordship.
No, that is not the case, my lord. He has shown me the instruction. I have seen it, my lord. It's that document says that the education department has forwarded certain documents to the pension and public grievances department. Now the pension public grievances writes back that in fact you have shown to have forwarded those documents to us, but that has actually not been forwarded. That is the case, my lord. And so far as that last line is concerned, that is not the interpretation, my lord. Initially, it was fixed in a correct manner, but the persons who died in harness, my lord, the family members are entitled to get the pension at the rate of full salary till the time they would have actually retired from service. This includes refixation in terms of new ROPs, the yearly increments and all. Now, in this case, the pension remain fixed for all the time, my lord. That is what is said in this paragraph. Initially, it was done correctly from the date it was sanctioned. But every year thereafter, the increments have to be included, the new fixation have to be given. Those have not been done. And the document, if lordship peruses the entire document, it clearly states that the documents have not been forwarded. In fact, the education department has said that they have forwarded, but the pension and public grievances have not received it.
One document that is on 15/9/2025, and that the documents, lordship,
They've not received them. I don't have any problem if further 1 week time is granted, but the instruction has not been placed correctly, my lord. That's the thing.
So, Lordship, that was forwarded by the inspector of school to the director of pension. So after taking this into cognizance and after when they tried to proceed, Your Lordship, is further documents were required. So for that purpose, is to the inspector of school, the recent communication has been written that they are requested to submit a pension proposal for revision of pension adhering to government OM dated 26/8/1980 issued by the government of Assam in the.
No, Mr. Devri,
Yes,
you'll see, this pension has already been granted. Then his case is that subsequently it has not been reviewed and the increment is not added.
Yes. Yes, yes.
So why documents are required? What documents are required?
Your Lordship, the inspector of school has to.
Mr. Devri, it seems that you failed to explain the matter proper. Let the director remain present in the court.
May I, Your Lordship, once, Your Lordship, that which the communication that has been written to me, addressed to me, Your Lordship. May Your Lordship, that on the last page, Your Lordship. It is pertinent to be stated that the said amount of special pension issued by this director had been fixed based on the last basic pay drawn by the deceased pensioner, which did not include any proportional benefit, increment benefit, and other. So that proposal has to come from the inspector of schools, Your Lordship, with certain updation. Your Lordship. So, Lordship.
No, who is
we have been
responsible for
continuously
the same?
striving for and doing the trying to.
Who is, no, you tell me who is responsible for doing the same? The
Lordship,
content now?
Lordship, if the inspector of schools, in terms of this communication, if they furnishes the necessary,
No, they have already furnished those documents and you were saying that those documents are nothing.
Lordship, Lordship, these particular documents with, in both the communication, it has been written that, Your Lordship, though they had furnished, their concerned official of the inspector of schools had admitted that though it was addressed to them and my senior colleague has handed over to me, and I accordingly send the communications to the concerned department. And but practically in hard copy, these documents were not sent and that request been that has been endorsed and accepted by the.
Yes,
accepted by the.
Mr. Sisti, whether the documents required by the director has been forwarded by the inspector.
I know. Instruction said it was forwarded, but whether he's elected in hard copy, it was not there. So that instruction I'll have to take. He said that on the hard copy, those documents are not there.
No.
Whether it is correct or not. is only-
If soft copy is forwarded to the department, to the director, then why hard copy is necessary?
Why it is there, but it's there.
Mr. Devri,
Lordship,
why hard copy is necessary?
Lordship, may I, here also, just 1 minute. The office of the undersigned by letter number 4311 such dated WPC number such has requested the Director of Secondary Education Assam to submit some documents relevant to the claim of the concerned petitioner. In response, the Director of Secondary Education by letter such and such under reference to copy enclosed has informed the Directorate that the Inspector of Schools Nalbari by letter dated 15/9/25 at reference 1 has submitted the relevant documents to this Directorate. On inquiry of the same, it has been found that the Inspector of Schools Nalbari has not submitted the letter documents to this Directorate till date, which has later been agreed by Sri Ram Sharma, UDA, contact number such and such of the Office of the Inspector of Schools, Nalbari over phone. However, though the letter dated 15/9/25 along with some documents have been collected from the Inspector of Schools, Nalbari through WhatsApp, copy and source, but it may be pointed out that the said letter did not include the proposal for revision of special family pension. So, Lordship, that communication which was addressed to me. So, Lordship,
No, whether such proposal is required in every year.
Lordship, it says that it is the proposal for revision of special family pension. Lordship. Perhaps this needs to come. That's why they have written this communication to the Inspector of School, which I have.
So taking the circumstances into account, as we have been trying your lordship, it's not that. We have,
No, Mr. Devi, you see, this contempt petition is of,
16.
of the year 2016.
Lordship, I have filed my Wakalatnama on 4th December 2025 here.
Mhm.
So normally it doesn't have been such long because we have been, but we are trying your lordship, since there's some due to technical issue, it is not that we are
No,
taking it
no,
off worry.
If you see the plight of the, this, petitioner, even after passing the order
Not
by
that,
this
he
committee,
has
writ
not able to
petition,
anything, perhaps this revised paper, revised record, he has been
The
availing.
problem here is for the period 3/11/1992 to 31/12/2009, on which that the person concerned would have retired, my lord. During this period, the entire pension was at a fixed rate. And if that is corrected, subsequently, as of today, I would be getting a much higher amount. That's the problem.
Enhancement.
no, is it the position that in, each and every year, pension proposal has to be received from the inspector of school?
No, no, not at all. They committed the mistake initially. That's why this has happened. From
Mr. Devi, I am giving you another chance to comply with the order of the school. Within 1 week, you have to comply with
Lordship,
the order.
Lordship. Yes, the director had communicated the inspector of school to provide the required.
No, we are not concerned with that. We are concerned with you. You were to implement the order of the court. Heard, Mr. P. Sharma, learned counsel for the petitioner, Mr. Devi for the contempt number 5 and 6. Mr. Sisti for contempt number 8. Mr. Sharma, learned counsel for the petitioner, has drawn the attention of this court to the order dated 15/10/2025 passed by this court. Wherein direction was issued to Mr. Devi, learned counsel for the contempt number 5 and 6 to produce the compliance order. Compliance order. 6 and
7.
6 and 7 to produce the compliance order before this court. But Mr. Devi, learned counsel for the contempt number 6 and 7 has produced some documents relating to communication between the director and the director of pension and the inspector of school and this in Nalbari. And submits that due to non-receipt of pension proposal from the inspector of school, the order of this court could not be complied with. The explanation so put forwarded by Mr. Devi for failing to comply with the order of this court left this court unimpressed. And accordingly, last chance is afforded to the contender number 6 and 7 to comply with the order of this court within a period of 1 week from today. Place the matter on 14 November. In the event of failing to comply with the order of this court, the court will consider directing the director, the contender number 6 and 7 to personally present before this court. List accordingly.
Item 30. Lordship, may I pray for 2 more further days? Because it is 19, on 19.
May I please, your lordship?
Yes.
Lordship, last occasion, the department has filed a speaking order, lordship.
Yes.
I have to submit some documents, so 2 weeks time may granted for file an affidavit, lordship. And lordship, one more aspect, lordship, the petitioner had submitted their attendance register before the director office. That may call for, lordship. Yes, dear. Maybe, lordship.
He has not delivered silence proper our concern, our part, respondent concern. If the activity is ordered, they can challenge the writ petition, lordship.
No,
What is the
lordship.
direction? Direction is a simple paragraph 5, lordship, mechanically.
Lordship, I will file an affidavit, lordship, regarding the speaking order, lordship.
Is directed to lordship to do the needful as provided in paragraph 3 and 4. There is no specific mandamus yet, lordship. Matter is demand back to the Secretary, Government of Assam, and to the needful as provided in the paragraph 3 and 4 of the
earlier order dated 8/11/2021.
Social letter file affidavit.
But contempt case, Lordship, we have complied. Now they will file affidavit.
We'll say
Not compliant, Lordship. It is,
If it is not compliant, they can challenge it in the writ petition, Lordship. That is the procedure.
hard. Sharma learned for the petition and Mr. Assembly says they contact contempt. Ms. Sharma submits that she may be granted 2 weeks time to file affidavit. We are allowed this the matter after 2 weeks.
and Lordship, attendance register may call for Lordship.
Sentence register you also yourself.
From director office, Lordship, they have submitted before the
Contempt
date.
petition, Lordship, how can it open? See, it's a contempt petition, Lordship. 31.
Yes.
Lordship, 3.5 years gone, Lordship, after issuing of the notice.
Pardon?
3.5 years gone, Lordship, after issuing of the notice in this case. The principal was asked by the department to send a proposal. So the principal sent a proposal earlier, madam. That was some justification paid there. Then again the principal was directed to send this proposal. Then this principal has sent the first proposal on 13/10/2025 on this. They took a petition in the process. And it is 4 weeks time for the similar decided I think. The petition was decided.
So now you have received the proposal
Yes, madam.
from the principal.
Principal last line first paragraph. Earlier the principal
Okay. You produce the compliance order on next day. Third, Mr. Gogoi, learned counsel for the petitioner, sir. Yes, thus learned something counsel for the response in higher education department. Sir, does it produce one letter to the joint director of higher education Assam Kalipara dated. Where is the date of this letter? To put. Not record. So this is the way how your government is functioning. Dated nil. And on the strength of the said document, said letter, Mr. Das submits that the principal of Panigao OPT College, Lakhimpur has already sent a proposal. Submitted the rectified proposal by letter dated 13/10/2025. And now the case of the petitioner is under process at the directorate. And therefore, Mr. Das submits that he may be granted 4 weeks time to produce the compliance order. Okay. To complete the entire process, fair is accordingly allowed. This is the matter on.
That may be
4 weeks.
That means on 5th December.
The letter produced before the court today shall be marked as annexary and be taken to the record.
Well, can it be before or after this? On 8th December. 8th December.
Deeply obliged.
Item 32.
32 Lordship, we have issued the compliance order.
The last time I thought this was placed, my lord, I think, my lord, whether, my lord, my lord, they had taken a stand, my lord, which is, my lord, not permissible, because the direction was to appoint. Now they have applied the mind on this honorable course order method.
on the last occasion, they wanted to obtain instruction. They said the review is going to be filed. My lord, the issue here is, my lord, that she had, my lord, secured on, my lord, 59% marks. And, my lord, she applied to the reserve category. This one, since there was no candidate in the reserve, my lord, unreserved category, my lord, she prayed, my lord, that she may be considered for the general category. This honorable court said, my lord, consider her marks. If she is eligible, appoint her. Now they took a stand, my lord, that she had come here by relaxed age. That was not a consideration in the affidavit. They did not take up that stand. Even if that stand is taken, my lord, that will also not be maintainable, my lord. If they file a review, my lord, will not say that. But then this order as such is contumacious, my lord. On the last occasion, that's why they took time to obtain instruction, my lord, whether the review has been filed or they are going to, or say they will file a review. That was not done. That has not been done so far, my lord. Because they admit, my lord, the vacancies were not filled up because of lack of deserving candidates, my lord, in the unreserved category. That was my case. There was no, my lord, candidate in the unreserved category. Therefore, my lord, lordship's order, lordship will see the order at page 10, my lord. Their case was that I did not get secured, my lord, secured 60% marks in, my lord, in the TET examination, which is required for a general category candidate. I had 59% marks. Para 10, my lord. Page 13. In view of the above conclusion as reached in the matter, as well as applying the ratio available in the decision of the Honorable Supreme Court in render the case of Vikas Sankla, it is hereby directed that the respondent authorities more particular respondent number 2 shall now consider the case of petition against any of the advertised post of graduate teacher in the subject of political science Bengali medium if any of the 3 districts so and so, so and so, so and so, and thereafter reckoning the merit position as obtained by the petition in the selection process involved, and if it is found that the petition in view of marks scored by her is entitled to be so appointed even in vacant post, including the unreserved post category so and so, the respondent number 2 shall proceed to appoint the petitioner herein against one of such posts. Now they have taken a stand, my lord, that she has come, my lord, with some relaxed age, my lord, consideration, my lord. Even whether that will be maintainable, that's another issue, my lord. But then they could not have passed this order, my lord, by sitting in appeal over order of this on the court.
Mr. Siste?
Then I will have to take a exception of it. Taken one side.
So you see, if they're going by this paragraph number 10, then it is said that you have complied with the order of this court. Or Mr. M. Dotto, learned for the petitioner, Mr. S.M.P. Siste, learned counsel for the complainant. During the course of deliberation, Mr. Siste has produced an order dated 21/6/2025 and submits that the order of this court has been complied with. But Mr. Dotto, learned counsel for the contempt for the petitioner, drawing the attention of this court to the paragraph number 10 of the order dated
Lord, 10/6/2024, my lord.
10/6/2024 submits that the order produced before the court today, the order passed by the Director, Secondary Education Assam, dated 21/6/2025 is contemptuous in nature, and the Director has been sitting as appellate authority of this court. That this instance, Mr. Siste submits that he may be granted some time to obtain inspection. There is allowed to exercise the matter on Friday.
Yes.
My lord.
Right.
7th November.
Deeply obliged, your worship.
Item 34.
May please, your lordship, for non-compliance of order dated 4/2/2025. Kindly sit with. Right.
Here, that order here to compliance with it's a long order of.
Okay, you go through the order.
Yes, because we have to
You
go
go
through
through
it.
the order.
It's a very
You
long.
come back in the next week.
Next slide.
Your
Lordship,
instruction.
respondent authority was directed, earlier order dated 17/10/2025, Lordship.
Hmm.
They were directed to file affidavit through these orders.
Yes, then I.
Because my post was provincialized in under the Act 2013, Lordship.
Hmm.
But wrongly provincialized in the name of one Digonto Tait. I am Hindi teacher. And my post is
Hmm.
provincialized with the name of Digonto Tait, one science teacher, Lordship.
Hmm.
That is the case. And that has been already admitted by the respondent authority. It has already been reflected in the order, Lordship.
Then I'll file it by 1 week. Yes, I'll file it. By this week, sir.
But they neither rectified that order nor cancel the order of provincialization of Digonto Tait, but not rectified with correcting my name, including my name in the provincialization list.
Okay. Part Mr. M.K. Now, learned counsel for the petitioner. 60, learned standing counsel for the contestant. Learned
One and
counsel
two.
for the contestant. During the course of deliberation, Mr. 60 has produced one order of the director dated 1st of November 2025 and submits that the order of this court is complied with. Mr. Nayak, learned counsel for the petitioner, has pointed out that by the order dated 17/10/2025, the contestant was directed to file an affidavit bringing on record the instruction. And Mr. Sisti, learned counsel for the contestant, submits that he may be granted some time to file to bring on record the order dated 1st of November 2025 by filing in the second. Where allowed, this is a list of matter. Friday?
Yes, by Friday I will find it.
The order for this to report to the self marked as annexed. Okay, and we take to the record.
35.
Obliged, Lord.
My lord, here service is completed. So I pray for listing this next week because in this month the influx was. The matter is very simple. It is the headmanship he was not given, that is why. So it will be come to 3 years. Term will be expired on 27th of November. But before that, some decision may come. That is why next week. my lord.
Okay. Art, Mr. Purva, learned
MG
counsel for the petitioner. Mr. Das for respondent number.
One and three.
1 and 3, and Mr. Learned counsel referring on behalf of Mr. P.J. Pokam, learned counsel for the respondent number 2. Mr. Borgo submits that service in this matter has already been completed and the matter may be listed for admission hearing.
Yes, next week.
According to it is provided that list the matter on
14th November,
or date
12 November.
12
12.
for
Obliged.
admission hearing.
Items for hearing 36 and 37.
Mr. Kamar, you have already completed your argument.
My lord, on the last time I pointed out, factually, I have given the broader aspect, my lord. Now, my lord, 2-3 points I'd like to submit on factual, and then I'd like to go on the legal aspect. If he is heard, he may be heard today. I'm ready now.
Regarding my lord, earlier that case diary of 6/36 of 2016, that case diary received, my lord.
As they receive.
Case diary received. I have also flag marked the, my lord, vital statement of the, my lord, controller and registrar of the Dibrugarh University. And my lord, one WS also in the title suit, also one WS also submitted by the respondent, that is Dibrugarh University registrar and controller. That also, my lord, I have flag marked. And my lord, regarding the present case, already considering the finding materials against the accused persons, that already started submitted in this case, my lord. And in the other case, my lord, wherein my lord, the present petitioner has, my lord, to file FIR against those persons. In that case also, my lord, final report submitted. So, my lord, from all these materials, my lord, my prayer before lordship now, my lord, That is the forgery of the document, my lord. That is the certificate of the educational qualification. Those matters are, my lord, now matters of evidence, only can be decided by the trial court. And my lord, otherwise from the materials available on record, my lord, those against the petitioner, but those I have pointed out, I have also, my lord, flagged mark. Considering all these aspects, my clear before your lordship. So, my lord, it's only the trial court is the best court at this point of time after taking evidence to decide the matter, my lord, entire matter. Considering the, my lord, other without taking evidence, without cross-examining, my lord, the witnesses, my lord, it cannot be difficult for this honorable court to ascertain regarding the, to decide the matter regarding that issue regarding forgery of the
Where is the case diary?
case diary, my lord, yes, it is in the records, my lord. Both the case diaries in the one file, my lord, 636.
Okay. Your part is over.
That is my submission, my lord, regarding.
Yes.
My lord,
Can you complete the matter today?
I don't think, because I've got 4-5 decisions, because in this case, just one legal aspect I would like to point out first, that the nomination was filed giving a wrong affidavit as it is tried to be projected, my lord. Now, whether in that aspect, a private FIR can be filed, whether the informant should have approached the returning officer or for that the election office, my lord. Thereafter, the things would have evolved, my lord. Competition, no. সদায় উল্টা প্রশ্ন। উস,
Please. Possible.
Just taking, drawing your lordship attention at annexure 1, page 18, my lord.
Page 18.
18, the FIR on the basis of which the charge sheet has been filed, my lord.
Yes.
No. First paragraph is there, shall I read, or the second paragraph is the main paragraph? Subsequently, in the affidavit filed with the nomination paper, Rana Goswami claimed that he has completed the BCom from JB College, Jorat under Dibrugarh University and passed in the year 1981. But subsequently, petitioner query came to know that the said Rana Goswami has not passed the BCom examination in the year 1981. So if I pause here for a moment, I would like to stretch on the first line, the affidavit filed with the nomination paper. So once the nomination paper was before the returning officer, my lord, as per the law, it is to be taken up under the People's Representative Act, my lord, 125A. 125A of the People's Representation Act 1951.
Yes.
My lord. 9. रातिपुৱাই দিছিলো লিষ্ট অফ হা দিয়া নাছিল না লিষ্ট অফ বলো কাক দিছিল আপুনি we have submitted a list of books. One of the books was this, my lord. So 125A, penalty for filing false affidavit. A candidate who himself or through his proposer with intent to be elected in fails to furnish information relating to subsection 1 of section 33A, give false information which is no or reasons to believe conceals any information information in his nomination paper delivered under subsection 1 of section 33 in his affidavit which is required to be delivered claimed under section 2 of 33 as the case may be shall not be anything contained in any other law for the timing for be punishable with imprisonment for a term which may extend to 6 years or 6 months, sorry, or with the fine on both. So there is specific provision, my lord. Just a preliminary, I'm submitting, I've got certain judgments also. So it will take some time, my lord. Today I'm just pointing it out so that he can get the notice and come also. Section 125A. No, legal aspect, that's why we should send correct. And if we go to the IPC 181, all these things is to be read together, my lord.
IPC section?
181, my lord. False statement on oath or affirmation to public servant or person authorized to administer an oath. Whoever being legally bound by an oath or affirmation to the state the truth or any subject to the public servant or other authorized person, the administrator such oath affirmation makes to such public servant or other person ever touching the subject any statement which false and which he either knows or believes to be false or does not believe to be true shall be punishment of neither which may extend to 3 years and also liable to be fined. So these are to be read together, my lord, when an affidavit has been filed before the, along with the nomination paper, my lord. So that is for the authority, then he will make an inquiry, call for a report. Thereafter, the opinion that has come, that will take a final shape, my lord. That is the judicial pronouncements are also there. So right now, my lord, there are two cases. One is regarding this point I have submitted today for appraisal to him also so that he can come prepare and to your lordship also. And in the other case, there was no investigation at all because there are two things now, my lord. JB Law College has declared me as pass and I have annexed that certificate, which your lordship by now must have got it, my lord. I have filed a title suit also wherein the register and all has been made a party to it, my lord. And that is at page 53. So on the basis of this, I have made the declaration, my lord. So at that time, in my case, you can let one ready go second petition.
Page number 50?
53 of this present, my lord. On the basis of this,
No,
I
this
have claimed.
petition, criminal petition or revision
Oh,
petition?
no, criminal petition, my lord. Criminal petition 74, my lord. It is in this case, I have given and also annexed this. In response to your legal notice dated such, I am furnishing the following points for clarification. The result of BCom examination held in 1980 was declared in 81 and as
No,
per.
Mr.
My
Amar,
my lord.
in criminal petition, page number 53 is the last page.
My lord, Annexure 9, my lord, and a reply made by the Jagannath Bora College principal, my lord. Yes, my last page. Last page probably.
Okay.
Salary, my lord. Because advocate of Rana Goswami has issued a notice. To that, the principal has response. In response to your legal notice, no number, dated 7/4/2016, I am furnishing the following points for clarification. The result of BCom examination held in 80 was declared in 81 and as per result sheet, Rana Goswami bearing roll number 858 was declared passed. The university provided furnished mark sheet to the college in respect of each student candidate appeared in that examination, and the college authority delivered the same to the candidate. Further, the college authority issued provisional pass certificate to the candidate on perusal of the mark sheet and result sheet provided by the university. Other records of the period are not available in the college except the result sheet issued by the university. No two different mark sheet were issued to Goswami by this college, so far my knowledge goes. So it was 1 NM, and these are the two things. And I myself has taken the responsibility to approach the civil court and filed a title suit, my lord, wherein the Dibrugarh University, the race controller examination, and JB College are made party, my lord, to with a prayer to declare that my results are the genuine one, my lord. My prayer, my lord, at page 44. So there may be some mistake we don't know, so that is the why, my lord. And And in my case, my lord, wherein I lodged the FIR in the other case, my lord, the IO has not properly invested the matter. In a routine manner, they have submitted the final report, and unfortunately, the court was also accepted it without looking much going deep into the matter, though I have filed an objection into its acceptance. That being the position, there needs some investigation to it. None from the JB college probably has been examined. What is in the case diary, I don't know, my lord, but from the order sheet, it gets reflected that only 3% has been examined, my lord. So that's need to be revisited according to my respectful submission. The impugn order, annexure 9, page 59 of the other criminal revision, my lord. So if before
The principal JB College was not examined.
not according to me, I don't know, my lord, what is there, my lord, because we are not served copy. He will throw light, my lord, and your lordship may have a look to it. Because that position would have been cleared only by that person, my lord. What is the actual happening, my lord? If we see from the order sheet, my lord, IO examined the informant along with two other witnesses of Dibrugarh University. As it is reflected, the order under challenge at annexure 9, page 59 of the criminal revision 107. Last page of that also. Because there are now two things emerging, one from the RTI reply and one the certificate which was given to me by JB College. And JB College has, a principal has responded to the lawyer's notice, my lord. Okay. And on the next date, we will make the legal submission then, my lord. Okay. Because these new things has come up, new judgments have come up actually.
But the problem is that.
No, just half an hour, my lord, because
Better in the-
I have started today because now your lordship, we are all exhausted, my lord. We'll do it on a convenient date. If at 2 it is fixed, also no issue, my lord. Half an hour or 40 minutes I'll take, my lord.
Okay, fine.
My lord, can I give a preferable date? Huh?
On a hearing.
Hearing this. Oh, 24, my lord.
20 November.
20, I'll be out of station. Kindly, any date on 24th, actually,
25th, not 24th.
or 25th, take it, no. 25th Tuesday at 2? My lord, at 2?
Hmm.
How about?
Yeah. I have set much, my lord, the statement of the controller and the registrar, and also this is the, my lord, legal notice to the reply of the principal JB College, but that reply of the, my lord, registrar is also available, I have said.
Much obliged, my lord.